Good evening, and welcome to the public hearing for the Livingston Zoning Board of Adjustment. Today is August 26, 2025. If you're an applicant for a D or use variance, you should be aware that such a variance can only be granted after showing that special reasons for the grant of that variance exist, and that variance can be granted without substantial detriment to the zoning plan of the Township of Livingston. You should also be aware that in order to be granted such a variance, you will require an affirmative vote of 5 members of the 7-member Board of Adjustment. Other variances require a majority of 4 members to grant that variance. If you're an applicant for any variance and your variance is denied by this board, you have a right to appeal to the Superior Court of the State of New Jersey within 45 days of notice of decision, excuse me, and that court may overturn the decision of this board. If you're an objector to any type of variance that has been granted, you too may appeal to the Superior Court of the State of New Jersey within 45 days of the notice of decision. If you do file an appeal, I ask that you please provide a copy of your complaint to the Planning Administrator, Jackie Hollis. Pursuant to the requirements of the Open Public Meeting Act, also known as the Sunshine Law, adequate notice of this meeting was provided to the Star Ledger and West Essex Tribune, and a copy was also posted on the bulletin board of the municipal building. In addition to having notice posted, notice of this meeting was placed on the township's website. Members of the public will have an opportunity to ask questions or to make statements regarding each application at the appropriate time. When the time comes, if you'd like to address the board, please come to the front and use a microphone so we can make sure your comments or questions are part of the record. And I'd like to say I appreciate this meeting's a little late today. I had a conflict, so I appreciate everyone coming in late today. If we could call the roll, please.
Mr. Kenya, here. Mr. Horn?
Here.
Mr. Shah?
Here.
Okay, Mr. Sherman?
Here.
Mr. Wiseman?
Here.
Ms. Soho?
Here.
Ms. Khan is out. Mr. Beer?
Here. Okay, we have 2 adjournments today. 64 Hillside Avenue, Block 3901, Lot 76. If you're here for that application, it's been adjourned to October 28th, 2025. It will not be renoticed. Also, if you're here for Block 4501, Lot 18, 20 Cambridge Road, that too has been adjourned. Jackie, that's also to October? Okay, so it's the same date, October 28th. If you're here for that application, you no need to stay. So, 2 down. Kenya, if you would like to call the next application.
Okay, next one. Block 4900, Lot 55, application 75 Ridge Drive, application number 2025-29-V, Alok and Ankita Batra. Application seeks approval for the first floor addition at the rear and second floor addition in the violation of the following section: 170-87L, 1C, corner lot setback 40 feet required, 23.8 feet proposed, 16.2 feet variance requested. 170-87CC3, habitable floor area ratio 21% allowed, 23.3% proposed, 2.3% variance requested.
All right, so I'm assuming that you are the Bothras? Yes. You're the owners of the property, correct? This is our second time we were here on meeting. Okay, wait, you gotta, click on the button. Good, okay.
Can you guys hear me?
Yes, perfect.
Sorry.
So I'm just confirming you are the owners of the property,
Yes,
correct?
yes.
Okay, and you have some witnesses tonight that are gonna testify with regard to your application, correct?
That's right.
Okay, so we have the architect and engineer? Yes. Okay. Can we tell the engineer? He's dying to tell you all about the numbers and everything. All right, so why don't we...
What's wrong with that?
Absolutely nothing. Just except the guys who build bridges. Okay, so who are you going to call first?
Architect?
Architect? Okay. So why don't you go to the microphone? I'm going to swear him in. Not swear at him, I'm going to swear him in. Okay, sir, do you... All right.
It works.
You raise your hand. Do you swear or affirm to tell the truth for the zoning board tonight, so help you God?
I do.
Okay, can you do us the favor of stating and spelling your name for the record?
Sure. It's Yuval, Y-U-V-A-L, middle initial I, Wellish, W-E-L-L-I-S-C-H.
Okay, and you've appeared before the board previously, correct?
Many times.
Okay, and you've been qualified in the field of architecture, correct?
Yes,
And your New Jersey state license is still active, correct?
it is.
All right, you haven't received any emails today, right?
No.
Okay. Chairman?
Okay, does anyone on the board have any questions or objections regarding this witness? There being no objections, the witness is accepted as expert in architecture.
Okay. So, I'm not sure I'm that good at this thing. You want to help me a little bit with this? Just like last time. Thank you. What would you like, sir? If you can put the floor plans. I mean, I have them over here, but they're so far away.
Yeah,
We prefer to have it on the screen so it gets recorded.
I know the members have a copy, right? So I'm pretty much gonna,
No, it's not up. Oh, it's getting closer.
that's some of it.
Magic.
okay, here we go.
Yeah, how do you,
Is that the house?
oh,
Oh,
how do you make it? You know how to make it like smaller? Yeah, this goes up and down. Oh, oops, he goes the other way. Yeah, I'm trying to. There you go.
oops.
Doesn't work the same way as I want it to. Okay, good. Well, basically, we all went through this like the last time, so I'm sure the board is pretty much familiar with that. I'll just try to get the front over here. Oops, I did something wrong. That's okay. Where's my plan? You know how to put it back? I'm not very good at this. Let's go to the first one.
There you go. There you go.
Oh, that's a go. It worked. It worked. Technique. We work with the computer every day, but we're not mastering them. So, okay, so the last time we attended was on May 29 and 2025, and since that time, the engineer, my client, and myself tried to work very hard to pretty much adhere to what the board had said. And we carefully keeping in mind all the things that everybody said. And the main thing was practically making the house smaller to adhere as much as possible to the zoning. So let's talk about the habitable floor area. In the last hearing, the proposed habitable floor area was, that what we proposed was 4,126. And the maximum allowed in this area, in this zone is 3,520. So we cut it below that number. Right now, the house is 3,517 square feet with an HFA ratio of 0.233. And before it was higher than that. The reduction represents 609 square feet less than the original application, which is approximately 14.8% of the house, almost 15, decreased from the last time. By making this adjustment, the project is now fully compliant with the floor area limit of the zone, though we are still requesting a relief on the ratio. We are about 347 square feet above the number that this lot allows, but at least we comply with the maximum. We have a setback issue on Burnett, which is the side street, because it's existing, but we pulled, not on this one, sorry. I'll try not to make a mistake this time. You want to pull it to the next one? Oh, you do it with your finger? Absolutely crazy. There you go. Just pull it this way so we can see the side. Okay. So the addition before went all the way to here, and now we pulled it all the way to here, which is, you know, instead of like 23.8 feet before, now it's 38.2. We're still not reaching the 40, which is the one that the zone allows, but we just couldn't make the rooms like any smaller. We wouldn't get the stairs to work and all that stuff. So right now, we're just 20 inches over the allowed 40 feet. That's on Burnett. On the main street, we're fine. As the board knows, the required FAR in this zone is 0.21, and the original proposal last time was 0.27. Well, we brought it down to 0.233. Like I said before, it's about 14. We cut about 14.5% of the house. Basically, the house does look the same, but it's a lot more reversed, like away from the side street. I know some board members were a little bit concerned about that, because when you go to the school, you see that. From the main road, not so bad, but so we pretty much reduced it that way. And that's what we did.
Does anyone on the board have any questions for this witness?
What's the height to the top peak of the house from the?
What is the height right now?
Yeah,
It's less than what is the maximum allowed. Can you get me the first one?
they're just making almost 35 almost.
Yeah,
That look pretty
right
big.
here. It's so small here. Yeah, the height is 34 feet, 7¼ inches.
Okay,
And that is measured in Livingston from the average ground to the top. So actually, in real life, it's not like that. It's a little bit less. All right, because the average is over here, this line. If you measure from the ground, it's different, but there are no measurements for that because the zoning department doesn't want that.
Anybody else have any questions for this witness? Does anybody in the public have any questions? Oh, I'm sorry, go ahead,
So
please.
that would make the attic taller than 7 feet at this point?
I'm not sure, but I
I mean, just
think it's
looking at the
about so.
proportions.
There's no limitation on that, so.
Correct, just want to make sure that it doesn't become a habitable
Oh, no,
area.
no, it will not.
Yeah.
By all means, it will not. There's no intention to do that.
So no problem with that being a condition of approval if we approve it, right?
I'm sorry?
No, there's no problem with the attic not being habitable?
No.
As a condition of approval?
Yes, you can put it as that, sure.
Does anybody else on the board have any questions for this witness? Does anybody in the public have any questions for this witness? Okay, one down, one to go.
Thank you.
All right. Do you swear for and tell the truth for the zoning board tonight, so help you God?
Yes, I do.
Okay, can you please state and spell your name for the record?
William Scott, S-C-O-T-T.
Okay, and you appeared at the last hearing, is that correct?
Yes, I did.
And you put your credentials on as an engineer, and it was accepted by the board, correct?
Yes.
And your license to practice in the state of New Jersey is still up to date, correct?
Yes, it is.
All right, I bet you checked your emails before you came up.
I do, yes.
Okay, there we go. Okay.
Does anyone on the board have any questions or objections regarding this witness? There being no objections, the witness is accepted as expert in professional engineering.
I don't recall there being any questions or concerns raised at the last board meeting, so to save time for the other applications, I'd rather just open myself up to any questions you might have regarding the site plan.
I appreciate that. Does anyone on the board have any questions regarding the site plan? Does anybody in the public have any questions regarding the site plan? Seems like there's no questions.
Thank you.
All right. Do you guys want to make any statement as the owners? You have an opportunity.
Last time when we were here, we had like 3 variance requests and 2 children. This time we have 3 children and 2 variant requests. We would really appreciate.
That was good.
well. I was in the labor in the last meeting, so I was at the hospital.
Yes.
Yeah.
We would really appreciate your blessings to the girl and us as a family with the variance.
Does anybody in the public want to make any statement regarding this application? Does anybody on the board want to make any statement regarding this application?
I just want to say thank you, appreciate it, right? I know it was definitely interesting circumstances with you worrying about your wife last time, right? And you took our feedback. I think the house now still gives you what you need from a size and scale, what we were looking for your family, but addressed our concerns about that community. My kid went to Burnett Hill, so I know exactly where this house is, and I know the side views of it. So I just wanted, on behalf of the board, to give you our appreciation and congratulations for making those modifications.
Yeah, I too want to thank you for doing your stressful time when you were having a baby and doing this, and you had to go back and, keeping the smile. Thank you very much for making the adjustment and coming back. But yeah, congratulations.
Does anybody on the board want to make a motion?
I'll make a motion to approve with the attic not being habitable as a condition of approval.
I'll second it. Okay, Mr. Sherman,
Yes.
Mr. Kenya, yes, Mr. Horn,
Yes.
Mr. Shah,
Yes.
Mr. Wiseman,
Yes.
Ms. Saul,
Yes.
Mr. Beer.
Yes.
Motion carries. Congratulations.
Congratulations. Good luck with the baby.
Yeah.
Try to get some sleep. I said try.
Okay, block 4001. Block 4001, lot 1502, 23 Harvest Lane, application number 2025-26-V. Bargo Modi, application seeks approval to finish the frame space to habitable living space in violation of the following section: 17087 BB4, habitable floor area, 3220 square feet allowed, 3835 square feet proposed, 615 square feet variance requested, 17087 CC4, habitable floor area ratio 30% allowed, 36.2% proposed, 6.2% variance requested.
Richard Skolnick, on behalf of the applicants. We are in the R4. We do need the floor area ratio variances. As mentioned, we're 615 square feet larger than permitted. This application was before you on May 29th. On that night, the architect, Eamon Sadra, and our planner, Alex Doherty, both testified. But at the end of the hearing, Mr. Wenzel pointed out that there was a recorded deed restriction on the property, if you recall. When the lot was created, the planning board had a condition in that approval that said no floor area ratio variances. So in essence, there was a title defect. Immediately after that meeting, the client hired me. We filed an application with the planning board to remove that deed restriction. And we had that hearing at the planning board in June, and by resolution memorialized on July 15th, the planning board lifted that deed restriction that said there could be no more variance applications. So we're back before you tonight requesting the relief on the maximum FAR and the floor area ratio. You've heard all the testimony. But we're going to do a quick summary to get you back into it. And there were some very unusual circumstances, if you may recall, where the builder built the house with extra space on the second floor, not a third floor attic, but extra space on the second floor. A CO was issued. My clients closed on the property, not being made aware by anybody along the way that variance relief would be necessary to build out this extra 615 square feet. So the building is constructed. You're going to see in the pictures, we believe there's absolutely no impact on any of the neighbors. Of course, the planning board has looked at it and said, we understand what happened here. You can go back to the Board of Adjustment for the relief. So that's where we're at. Mr. Dougherty, you understand you're still under oath
Yes.
from that meeting? Okay?
We'll
We're all-
just do it real quick. Do you swear affirm to tell the truth for the zoning board tonight, so help you God?
I do.
Okay, and Mr. Doherty has already been qualified in the field of planning, continues to be qualified in the field of planning.
Yes.
New Jersey license is up to date.
Current.
Okay, Chairman?
Okay. Chairman, we have the architect here if needed. My client's here, of course, as well. It's a D variance, so we need the 5 affirmative votes. Alex, can you run through your testimony?
Certainly. I'll be brief. I'll hit the points needed. As council indicated, we were here before, where we presented many of the exhibits. I'll breeze through them. On the screen is the zoning, outlined in red is approximately where we're at within the township of Livingston. We kind of hone in a little bit for those that are looking for orientation, right behind the Bottle King, the Bank of America, right off Route 10. We are kind of on that fringe zone, if you will, next to the B1. We are in the R4 zone, and this is block 4001, lot 15.02. This slide here from NJDEP GeoWeb represents a larger lot. This was part of a subdivision, as alluded to before, where that resolution was on there about, the ordinance was on there about the FAR for that subdivision. For purpose of this slide on 4, this is what's out there today. These are the existing property to the left, 23 Harvest Lane, part of that initial subdivision. You see, beautiful home, modern, clean, up to date. We take the drone out, give you some context of where we are. It is kind of a dead-end street back there. It doesn't have direct access to Route 10. Again, the CVS Bottle King is off to the left, and the bank is right behind the property. We have a unique situation where the property exists. I do testify nightly and daily. FAR, certainly very common request. This application for the board is unique, as council indicated. There are unique circumstances with this property. The existing structure, as it stands today, does have a window back here. It's elevated back here, right behind the bathroom on the second floor. And photo 13 is this void of dead space. As we can see, the HVAC electrical, it's been framed back here. This is the area in question that we're asking for some FAR relief. That relief, again, 36.2% where 30 is required for FAR. And then we have the habitable floor area, where we're over on by 615 square feet. We're asking for 3835, where 3,220 square feet is permitted. Unique about this in FAR is a way to control scale, bulks, and massing, ensure that there is a balance here, the property is not overly intensified. By that, the structure exists there today. It's kind of unique. It's just part of a subdivision. It certainly blends well. This is a unique FAR. We're not asking for an addition. We're not asking to grab attic space in that regards. This is on the second floor. It is there. Very unique from a planning standpoint. I have not come across this situation before, but from an FAR standpoint, and the reason we have FAR really is for the scale, size, and overall bulk controls. From a planning standpoint, that scale and massing of the structure is there today. This certainly would add a more efficient use of that second story. Again, this is not the attic, or we're asking for an addition off the rear. There are no violations by way of lot coverage, impervious coverage, setback relief. This, again, is an internal programming of the structure on that second floor. When we talk about that FAR, it's a little bit more relaxed than that Medici D1 for site suitability. We need to advance the municipal land use law, prove the positive, negative, and better zoning alternatives. So when we talk about this, advancing the municipal land use law, purpose A, the public health, safety, and the general welfare, the structure is modern, it will be code compliant, and really, meet the consumer expectations of a modern home. What's out there, again, that massing, that window in the back, you would naturally visually believe that was part of the second floor. Appropriate populations and appropriate locations. This, again, is a single-family home. The plans, and I'll show the plans in a moment, really is to divide this space, and the architect is here, as well as the applicant, really is to divide this space into 2 functional spaces. An additional bedroom, we have a growing family, we have a multi-generational family and guests, and then a large sunroom to enjoy relaxation and take, some light in. So for purposes of, can the site accommodate that additional bedroom, that intensity we look at for FAR on the property, we have an ample driveway, and garage. We are in that dead-end area here on Harvest. So when we talk about the driveway and the garage, adding an additional bedroom, we could certainly accommodate an additional vehicle if that did come with that. But again, I think the intent here is really to modernize the interior, which would advance the safety by getting this looked at, getting it up to code. Certainly density by way of it's still a single-family home. We have the space on the property to acquire that extra bedroom. We're not asking for 2 bedrooms, we're just asking for an additional one.
Alex,
Yes.
just in terms of the negative criteria here, to focus on that, do you see any detriments?
I do not.
To the neighbors here? Are they gonna understand or feel or be impacted in any way by this extra 615 square feet?
I do not
that's
see
on
that.
On the back there? Could you just
No,
show that?
right, because additionally, when we look at this, there's no visual change here to the built environment. We have the accommodations for parking. We're not asking for an addition over the patio or side yard. From a negative standpoint to the surrounding properties and the general neighborhood, from a planning standpoint, I don't see that. You know,
There's trees in the back there.
we have
with the
ample
neighbors.
buffer behind the property, as council's referring to. In the back of the site here, we have this large area that is open space, if you will. So from a screening standpoint, though the scale and massing of the structures there exist today, there will be no negative effect felt. Again, we're not asking for encroachments to the rear or side yard. I think we advance purpose I, desirable visual environment, keeping these structures intact from the public perspective in the public realm, which, as you see by the exhibits, very well designed, beautiful architectural homes here. Certainly, we could advance purpose G for sufficient space in appropriate locations. You know, this space is there on the second floor. And purpose M for, you know, encouraging coordination of public and private procedures, shaping development for more efficient use of land. We don't need to, you know, subdivide or clear cut any other open space to accommodate a larger home or that additional bedroom. We have that ability to do that here within the 4 walls of this structure. From a negative standpoint, I do not see any negative effects here. The essence of FAR is, can the site accommodate the additional floor area? I believe the site can certainly accommodate an additional floor area on that second floor, and it meets the controls for that. And from an architectural layout, or the architects here, the plan before the board on page 9, I know it's kind of sideways, a bedroom here, conceptual layout, and just an open floor plan for a nice sunroom to kind of take in that sun and the view through the backyard. A real modest application, straight down the middle, no additions, no violations of side yard setback. I think the statutory criteria for relief would be met and approval would be warranted. Again, FAR really is about controlling the scale and size and the intensity, and I think that's encumbered here with the existing conditions. Encompassed, yes.
So Chairman, you know, you heard the testimony in long form back in May. We wanted to get you back into it. Obviously, we could give you more information. We recognize you got 11 matters or so on the agenda tonight.
Thank you. Does anyone on the board have any comments or questions for this witness?
So I just want to confirm, for the area that you refer to as the sunroom, you're not adding any additional windows, you're using existing windows that are already there.
I believe the plan is to add some windows.
So there is an external view where the house will look different because now you're adding windows that don't exist today.
There is windows back there. I think the plan is to add a few more. It's a conceptual layout, but I think from a practical standpoint, a few windows will be placed there in the rear of the property. There's that buffer there as well, and where this side of the property, there is the bank on this side, where if you can see my mouse. The plan would be to really just add the windows, my understanding, to the exterior rear in that side of the building. But again, it's a conceptual layout. But from an exterior perspective, that may be the only minor modification is adding a window.
Right, so we are making modifications that would be seen by the public, given that they are changing and adding windows to the house.
In the literal sense, from the public realm, you would see the windows. I want to emphasize the location of the property in the dead end, our adjacent neighbors commercial, and the large buffer to the rear in the rear yard back there. The practicality of this being visually impaired, an impairment, I don't see that. I don't.
The structure cannot get larger because the planning board said you could only come to the Board of Adjustment for the 615 square feet that was built.
Understood.
But that also wouldn't preclude any exterior changes, correct? I mean, you still can make changes and stay within the 615 square feet and still make a change to the roof or do whatever else, and you'll still be within the 615 square feet.
The planning board did not get into that granularity, so to speak.
Well, they wouldn't, because it's not, that's building and it's not their purview anyway. So,
Is there, the board has some concerns about the placement of the windows? Because we could address that in some fashion. We didn't see that coming in as a critical item. We saw the bulk and the massing, which is not changing, but we could have the architect talk about what he wants to, what the concept might be, if that's a concern about
Well, I
placement of
was
windows.
queuing off the fact that the comment was made that there was no modifications to the external, to anything visible external to the house, and that does not sound like that's actually the case.
I did not
We
mean to
meant
misrepresent that.
Yeah.
I was referring to, typically I see FARs as an addition being put on.
Correct, but we normally don't see, as you rightly said, this kind of, the house built bigger than actually it really was intended within the rules.
And from a planning standpoint, adding windows certainly helps break up the bulk of structures, the glazing, and we don't want that continuous wall effect, especially in a residential neighborhood. I don't see adding windows as a negative effect of a substantial, issue. I think it only enhance the property, enhance quality of life on this, whether for this property and the current residents or those that would come in, behind and follow. I think overall, it's a beautiful building, and window placements are critical also for safety concerns. If the board does see that this FAR is appropriate, if it is a bedroom, it would need that second means of egress, which is that window as well. So to some capacity, windows would naturally come into play.
But there are there windows already in both the bedroom and that open room?
I believe there's just the one large window
So it
here.
would meet the egress standard because there is a large enough window there. So the window is not required. Adding additional windows are not required in order to meet safety standards.
If the bedroom's on that side, yeah.
Is the concern that the windows are going to have a negative impact on the public somehow? I'm trying to understand the planning concern that you're expressing.
My concern is that we are saying, and I understand, I was here last time to understand all kind of the stuff that happened, right? Is we're trying to say there's this unfinished space within the house and trying to let you potentially take advantage of that, right? Without changing anything that was built structurally from an outside in visibility. And now we're saying, we're going to make some changes to the outside because we're going to be adding windows. That's my concern, right? I'm trying to minimize the changes that were done, or at least my thoughts around that. That's where my head is.
We didn't see that coming in as the windows, in the placement. We could have the architect.
Well, why don't we just have a clarification here? Other than the addition of windows, there are going to be no other structural changes to what's already built. Is that accurate or inaccurate?
Confirm, I'm pretty sure. Okay, so, Mr. Sadra.
All right, Ms. Sadra, why don't you,
You could
just
do
get
it
the.
there, okay? We're gonna swear you
Yeah,
in?
swear.
Sure.
Sadra, do you swear affirm and tell the truth for the zoning board tonight?
I do.
And you're the architect on this project?
Yes, I am.
And you've been qualified many times here, and you remain qualified architect, New Jersey license, correct?
Yep, I didn't get any emails. Yep.
Okay, good. Maybe you need to turn on your phone, but okay,
Okay,
don't worry about it.
Warren's concerns here. Any other structural changes?
No, the roof will stay the same, the ceiling will stay the same, everything will stay the same, it's just the windows. And we really need the windows, especially where we have the bedroom, because there is no egress on that side. And I'm not 100% sure if these windows are egress windows either, the one that's shown in here. So eventually.
So would it be fair to say that the windows that would be placed would be solely for habitability and safety purposes?
Yeah, but again, he's asking for a sunroom as a design, so the sunroom known to have more windows.
Right, but
That's
there's
why we
no
added
other,
more windows for the
there's
sun.
no other structural change,
No
correct?
structure changes, no.
Okay. And you would agree with that being a condition, should the board agree to it, that would be a condition of approval? There's
No
no other
structural
structural changes other than the addition of windows,
Other
right?
than windows, yes.
I have a question for Mr. Cedra, since he's standing there. On the, like on the picture that you had up before showing the left side of the house, or that room, the wall sloped down, so like, it looks like a very short wall, like on the outside wall. Do you know what height that is on the?
I think it's about 6 foot to 6'8", I would assume.
Right
By
on-
looking at it, we never got inside, given the condition of, but by eye, it looks about 6 feet or 6'8" high.
Okay, I was just curious, because I know you have
Yeah.
a bathroom and a shower and whatever up against that wall, so it just doesn't look like it's a high wall, so.
Also, the plans, they're very conceptual, so we have also, we may change few things, like we're showing 2 bathrooms. I don't know if the building department will allow them 2 bathrooms or not. Maybe they say you only allowed 1 bathroom for this kind of house, given the water line, how big is the water line going to the house. If that's the case, so that's one of the bathroom will turn to a closet maybe.
Yeah,
But also, again, this is conceptual design. We're not touching the outside of the building. Any interior changes will be, in the inside.
I feel having 2 bathrooms in that space is a little bit excessive, given that it's a small property anyway. And now, because you have this extra space, now to add 2 additional bathrooms, 1 large walk-in closet, a substantially small sunroom.
I have
Actually-
to cut you off for a second, because we really
Yeah.
can't, it's up to them to decide what they can
But
put in.
we
how to
only,
divide it up.
technically, we're adding only 1 bathroom, because the other one is a relocated bathroom. It used to be in the hallway accessing the sunroom. So technically, we're adding only 1.
As part of a condition of approval, we get there, I assume we're not asking for a square foot over what we got. You're not going to configure anything that way. That's 38, 35 is the last we hear of square footage as a condition of approval.
That's
That's,
what's in
Yes.
the planning board, we've had back and
Yeah.
forth, 615 square feet.
yeah.
That's it.
That's, okay.
That's the size of the
Yeah, I mean,
room. That's it.
obviously, there's a certain amount of uncomfortableness in an R4 getting all this, but knowing the situation, and we're all trying to take all that into account. We just don't want to, have every house be totally oversized in so many ways.
We certainly appreciate the board's concerns, got a lot of FAR matters on, it's gonna hear a lot, and we understand how you have to balance. This had a very unique set of circumstances where the
Understood, yeah.
builder built this, didn't disclose permits, it's
Yeah.
Right, so just so everyone's aware, Mr. Skolnick said, the planning board, and I looked at the resolution again just now. The resolution from the planning board specifically states that they are removing that prior condition and replacing it with a new condition saying that they can make an application up to 615 feet. So what they're doing is they're making this application at the 615-foot square footage, and with the resulting FAR. So in essence, the planning board, for lack of a better term, has green-lighted the additional 615 feet, because otherwise they would not have removed the restriction. So just, it's a rather interesting, like a law school test here. I'm having bad flashbacks. But, where you have an interplay between your 2 land use boards, because you had the planning board give a condition, and then there was a overage of the condition. But then when the applicant went back to the board, which set forth the restriction, they removed the restriction, placed it with a new restriction, so that what they're saying is our new restriction is this number. So in essence, what I'm go back to is that fact that your fellow land use board determined that this applicant can make an application at the 615-foot square footage overage.
But the question that I have, though, is, I understand that, and obviously, there's nothing that precludes somebody in the future from going back there again to then get it changed again.
No,
right?
that I would let me clarify.
You can't-
At this point, the planning board has lost jurisdiction once this board
Does
gives
this? Okay.
its, assuming the board gives its variance. Now, at some later point, if there's a Mr. or Mrs. X out there that now want to do a renovation addition, guess what? They're coming back to this board. That the planning board resolution stays, and obviously they would have to deal with that in the future. I think they're going to have a very difficult time, regardless if any of us are here. But certainly, because now there are, what are we up to? Almost 3 resolutions on this one, Rich? This one is going to be, as they would say, papered up. So I doubt that there would be any ability to get any further relief. And in fact, I would even venture to say, if Mr. Skolnick came in, and he was I'm sure he was very aware of this, that if he came in with 616, I would have turned him around, not physically, but I would have turned him around and told him to go. But obviously, his client's adhering to the 615 to be in compliance with the planning board.
Despite my prodigious talents as a land use lawyer, I think it's going to be very difficult for any planning board to ever change the restriction, but this board could do it also. We're here with an application for the 615, which is the maximum. So if anybody wanted to come in, they'd still face a deed restriction. Mr. Wenzel clarified and specified that the restriction on not going for the FAR variances was not totally lifted. It was only lifted for the 615. But we did not, I need 5 votes tonight, and if the board feels it has to see the final window placement to feel comfortable with the application, then, we'll have to do that and come back. I prefer not to, but we need some flexibility. It's got to make sense to do it. We didn't see that as, in this circumstance, with that big backyard, with the commercial next door, as, really having any impact on the neighbors.
Okay, thank you. Does anybody else on the board have any other comments?
Yeah, so I just want to clarify where the 615 came from, if I understand it correctly, because we didn't get any new plans, right? So I'm assuming that you took those plans that had the number 615, the overage of 615, and that's what you went to the planning board with, and that's where the 615 came from, is that correct?
We had to calculate it,
Yeah,
right,
we
Mr.
did a
Sick?
calculation for the number, and that's how it came.
Right, and that's the same plans that you came in with last time as well, was that number? Okay. Just wanna clarify. Yep. Okay, just want to make sure there was.
Any other comments from the board? Any other questions or comments from the public? Please, you're up.
Sir, please raise your right hand. Do you swear affirm and tell the truth for the zoning board tonight?
Yes,
All right, can you please state and spell your name for the record?
sure. My name is Tarun Soni. The name Tarun is T for Tango, A for America, R for Rodak Builders, U for unfaithful, N for not trustworthy, and my last name is Soni, which is S for scamster, O for orange, N for not trustworthy, and I for Hindu. My address is 25 Harvest Lane, Livingston, New Jersey, 07039. You can already see the frustration, so I hope it's evident. I wanted to know, first of all, as the applicant, what was there which was built illegally, both from a height perspective as well as from the square footage perspective, and the town passed the CO. How did that happen?
Okay, so now is the time for comments about the application. And I think at the last board meeting where we had this application, this was discussed to some degree. This board has no authority nor involvement with anything involving the issuance of a CO or the approval of plans. Obviously, when the board gets these things in the normal course, right? The board gets the plans, they review the proposal and they vote on whether or not a variance is granted, whatever that variance is. That then goes over to the township for its professionals in the engineering and building department then take care of. So I think we all know that this, as Ms. Doherty already said from before, and from the last meeting, that this building's already built. But it still requires a variance. So that's why the jurisdiction remains with the board to determine whether or not that variance should or shouldn't be granted. And despite the fact that it's already built, not preferable, but despite the fact it's already built, the board still has jurisdiction to determine whether or not the variance should be granted. And obviously, the planning board also had their involvement in that. So this board really can't opine or give any clarity on the, nor does the applicant have to give any clarity on that issue. It's where we are today. So that's the sum and substance of that type of questions along those lines. So the board's really not in a position to speak on those issues.
But the board is taking the responsibility to pass these variances, correct? No. The board here, zoning board, is passing these variances.
Right, the variances are being presented to the board for their decision to grant two waivers, two variances for habitable floor area and floor area ratio. Yes.
Yeah. So my question is, when the builder was building the 615 square foot of space and it was building the illegal structure behind it, what it was approved for, didn't the board see it?
Okay, so once again, the board's not involved with the building of buildings. The board is only involved with when the application is presented to it. So the application is being presented now after the building is built. So there's no doubt that this application is being presented after the building was built. So the board would have no knowledge, nor the board ever has knowledge as to what's being built. They only have knowledge as to what's being proposed. And in this set of circumstances, it's already built.
Mr. Wenzel, can I try to clarify? I think because I think there's, and maybe Mr. Skolnick could help. I think the neighbor might be under the impression that I don't know what illegalities, we don't, a building, we don't get involved. No, but I just want to ask, I'm going to ask the attorney the question I think you want to ask. I believe that as far as zoning is concerned, that space in the back that was built, that looks like it could be built, was not habitable space. We could see it's not habitable space. So as far as we're concerned, right, Mr. Skolnick, it's in compliance with zoning as of today. Is that correct? So that part was not illegal? Because I think that's his question. He feels like that what was built was illegal from a zoning standpoint. I don't think that was the case. I think that's the question.
No.
We have a little bit of it different. I represented Mr. Sony at the planning board with my client to lift the condition.
Right.
So he's my former client. I'm not currently representing him, but I represented it both at the, I don't.
But he's
think
asking the question to you, so that's why I'm trying to clarify the question,
I
yes.
don't think you're objecting to this application, are you?
No.
Mr. Sony?
Not at all, not at all.
You want
I
this
am
to
not
be
objecting
approved?
to this
Hold on.
application.
You want this to be approved, right?
Absolutely.
Okay,
Okay,
I have
all
no-
right, wait.
See,
We got
I'm in the same boat.
we gotta bring in the horses.
Yeah.
The horses have left the barn, now we gotta bring them back in. So, all right. So, what's the comment?
My comment is that how does this kind of thing happen so that when we are the buyers of it, we are putting our family savings into it and we are tricked into this and nothing has been done against the builder, against the realtor premium one who has been doing this thing, and it's kind of deceiving and a cheat thing that they have been doing with us.
Okay, so I'm going to say this, that there are, I think at this point, about 90,000 attorneys in the state of New Jersey. There's probably somebody out there, other than me,
Yeah.
okay, because I represent the board, I can't represent you. But there's probably somebody out there who's very smart. I have 90,000, there's gotta be somebody who knows what they're doing. But there's probably 2 or 3. But there's gotta be, but I would suggest to you, I'm not saying that any of your comments are not accurate, they're not true, that they're off base. I'm saying to you that they are not things that the board would be able to answer for you, but one in which I think that you would need to seek out counsel to assist you with any and all issues you may have with regard to how this happened. So that's what I would suggest to you. But you're in favor of the application?
Sorry?
You're in favor of the application?
Of course, because I'm in the same boat which
Okay,
my
well,
application, Jackie
well-
will bring it soon. So
Okay.
one of the conditions is that you raise the question on windows, so I will be having windows as well in my
Well,
application.
then,
So,
I'm glad you're taking notes.
yes.
Yeah, but we're not
And
hearing your
I believe-
application now, so it doesn't really matter.
So
In other
I
words-
believe that when his is been approved, so there would be no arguments that when I present the case.
Well,
Every
you'll have to
every
present at that
application
time.
stands on its
Okay,
own.
We'll take it then.
Okay.
But,
Okay,
gotcha.
Thank
that-
you.
That was my comment.
Okay, appreciate it. And good luck.
If you could also help me, that is the board, like, what is the rule, like, in an R4 zone, if someone has.
See a guy with a suit and tie or a
Yeah,
bow
yeah.
tie? Those are the guys, there's a whole bunch of them here. They could probably answer that question for you.
The one without the
board-
bow tie.
Yeah, not the guy with the bow tie. That's why I
Yeah,
wear the
yeah,
bow
sure.
tie, so you know you don't ask me. But you find any one of these other fine members of the bar, not Dylan's, any one of these fine members of the bar, they'll be able to help you, okay?
Sure, thank
Just
you.
for the time's sake, if, if you're not opposing, can we just move on, please?
Yeah.
Yeah, I think so. Okay. Does anybody else want to make any comments? Would you like to have a closing statement?
No, not necessary.
Does anybody on the board want to make a statement? Does anybody on the board want to make a motion?
Well, I'll make a statement, because
Okay.
usually 615 is way too over for me. And it's very high. And also the fact that it was done also is not a relevant factor, because, again, it's unfinished space. So those aren't persuasive, but the fact that it was done, at least we could see the outcome. Sometimes we have to guess how it's going to look, and it's a guess. Here, we don't have to guess. We could see how they look. So that's one. But the second part that is distinguishing for me, and it's close, but it is distinguishing, this is almost like a zone into itself. When you come around the bend, if you see on that, the house turns. No, keep the slide up you had. You come down the street, and that house is faced this way, and then the street angles, and you have these two houses, separate. I don't even know that you could call them, they're zoned R4, because we have to divide up the town into various zones. But this is a pretty unique location, because it's overlooking the CVS. So you got to make this an attractive, and people could see it. So you want something sort of a little larger and nicer, which I think they've done a good job aesthetically. So you can see it, and at the same time, it's not, you want a nicer, bigger house because you want to attract people to buy such a house, because it's overlooking the, no offense, but the CVS and the Bottle King. In that sense, it's not a great location. So if this were coming to me before it was built, and they espoused such reasons under, AG and I, and those are the reasons, it looks like it would be, again, any other place. If it was just in between two other houses, 615 is too much. In this particular spot, this seems like, to me, a unique case where I think you're arguing it substantially benefits the town versus a smaller house, and that's what's most persuasive to me. I'll make a motion to approve based upon that, yeah.
So you are number one,
With the
right?
conditions of approval.
Yeah, he's number one. Yes, yes, he's number one.
Is number one?
And the conditions include, just to get on the record,
The conditions include no structural changes other than the windows. They're going to adhere to the planning board resolution.
which would include 615 square feet maximum.
That's the
Yep.
planning board resolution.
Who's seconding it? Done. All right, I'll do it.
I didn't get that, Mr. Chairman. Is there a second on that
Yes,
motion?
to Mr.
You
Kenyon.
gotta articulate that.
Yeah, thank you. Sorry for that. I was reluctant, but yes, that's it. Second, okay, Mr. Wiseman.
Yes.
Mr. Kenyon, Mr. Horn,
Yes.
Mr. Shah,
Yes.
Mr. Sherman.
Yes.
Do we need, Ms.?
No, yeah.
Yes. Yeah, because that's 7.
Yeah.
Okay, Ms. Saul. And
Yes.
Mr. Beer.
Yes,
Motion carries.
Thank you, we appreciate it.
thank you. Please call the next application. Yep, I just have to say that.
Okay, Block 401, Lot 53, 8 Hartstone Terrace, application number 2025-35-V, Adam and Jen Brenner. Application seeks approval to construct a retaining wall in the ground and in-ground pool in violation of the following section: 170-96A8F, swimming pool rear yard setback 20 feet required, 17.8 feet proposed, 2.2 feet variance requested. 170-96A8F, swimming pool side yard setback 20 feet required, 14.4 feet proposed, that's existing, 5.6 feet variance requested. 170-72C, 5C, retaining wall 5 feet required, 1 feet proposed, that is existing, 4 feet variance requested.
Okay, you're up.
Chairman, I remain Richard Skolnick. This is a pool, a case of a pool and some pool decking and a wall that were improperly installed a few feet from where they were shown on the plans. We were here on June 11th, and that night we presented the testimony of Mr. Roth, our engineer and planner, and the board expressed some serious concerns. We asked to adjourn to take a hard look at the issues. We've done so. Just to recap, there's essentially 3 variances. There's what I'm going to call a spa jacuzzi, and that spa jacuzzi has 7 square feet, 7 square feet total, a small triangular area that is located within the required 20-foot rear yard setback. It backs up against the school, and there's about a 2.2-foot deviation. So one of the variances is 7 square feet for the spa jacuzzi that exists. Second, there's 78 square feet of the existing pool that's located in the required side yard setback. And Mr. Roth is going to go through this. And our sense from the hearing was that the pool and spa encroachments into those 20-foot rear yard setbacks was not the board's greatest concern. That I don't want to say they were comfortable with it, but most of the discussion that we had was about a wall. It's a short, 3-foot-high wall that is in the required 5-foot side yard setback adjacent to the neighboring property at 10 Hartstone, excuse me. The board had concerns about whether this wall would impact the neighbor and whether it could be moved physically to comply. And we went back and we took a look at that issue, and it is possible to physically move that wall. It's a very, very significant undertaking, but physically it could be moved to comply with the 5 feet. But we just want to sort of get into that issue a little bit deeper and tell you why we don't think that it makes sense. We also, I believe, have the next door neighbor here to provide her commentary and her concerns, if any. And we'd like to present that information to the board. So with that, Mr. Roth, you understand you're still under oath?
Mr. Roth, do you swear affirm to tell the truth for the zoning board tonight, so help you God?
Yes, I do.
Mr. Roth, state and spell your name for the record.
Sure. Michael Roth, last name spelled R-O-T-H, from Roth Engineering.
Okay, Mr. Roth, you were qualified last time as an engineer, correct?
And planner.
And planner. And both of your certifications in those fields are up to date?
Yes, they're in good standing.
Okay.
Okay, so
Chairman?
if I may, Chairman, to
Yes,
try
go
to
ahead.
walk them through as expeditiously as we can. So, Mike, I said there were 3 variances. The first one is for a portion of the spot in the rear yard next to the Board of Education, the school property there. Can you just point that out on the screen?
Sure. Yeah, the two non-conforming conditions, we have the 7 square feet, which is this triangular area for the spa setback, and then this area here, which is 73 square feet in blue for the pool non-compliance setback.
I'm sorry, I had 78, but it's just 73 square feet.
Correct.
Okay. And then the third one was for the wall. Can you show us where that is on the drawing? And then we're going to go to the photographs
Sure.
and the aerial.
So the wall setback line is shown by the red dash line, so the non-conforming condition is what's hatched in red. So that area that's almost forms a triangle, it's about 40 linear feet in total. It runs 29 feet in the northern direction, and then about 10 feet in the east direction. So in total, it's approximately 80 square feet of wall and patio that does not comply
Okay.
with
So
that
the
5-foot
wall,
setback.
the wall and some of the patio were built within the required 5-foot setback area, and that's a violation also.
Correct.
Okay, can we go to the aerial to just hone in a little bit more than we had when we were here back in June?
Sure, so the plan that is before you is an aerial map. The subject property is outlined in red. The property that we're going to discuss in terms of its impact is 10 Hartstone Terrace. That's the property on the left side, which is to the west of the subject property. And as you can see from the aerial, there's an existing established landscape buffer that's along that common property line. And to coincide that with the site photograph, I'm gonna now flip to another exhibit. This is a shot looking northwest along that
Mr.
same.
Skolnick, was this part of what was submitted, or do we need to mark this?
This was submitted already. We have one new exhibit.
Correct.
that
Okay,
has
when we
some
get to that,
markings
we'll get
on
to
it,
that,
yeah.
okay.
So we could see the pool here. Where is the wall? Mike, can you use your cursor?
Yeah.
The wall and the patio okay, so that's there.
Yeah,
Okay, and that's 3 feet tall.
approximately, yes.
Okay. And then we have that tree line
Right.
next door. So we obviously would propose more trees to mitigate any impact. And we could add some trees.
Correct.
Right?
Yes.
We think this is, a very fertile and verdant buffer already, and a suitable buffer.
Correct.
Correct there? Okay.
Yes.
And we have the wrought iron fence, that's on the neighbor's property, actually?
That is correct.
Okay. And Mike, can you just talk about the grade change a little bit here?
Sure. As Mr. Skolnick noted, there's the wall that supports the pool patio is approximately 3 feet. As you go further towards the property line, there's actually a stone wall that's on the neighbor's property that's probably a couple feet. And then you have this evergreen buffer screen that measures probably about 15 feet. So in total, you have almost a 20-foot barrier between any view from the adjacent property to the subject property.
Okay, we have another view of this.
Yes, I'm going to flip to, so this is now, we're looking towards that common property line. We're looking west. And as you can see, I'll zoom in a little bit more. You can see the wall that's on the subject property, the other wall, and then this vast landscape buffer. So in my opinion, this is a no impact variance. There's no visual impact from the neighboring property onto the subject property.
Okay, and Mike, for tonight, we sort of added some markings to bring this out a little bit more. Can you show that?
Sure.
And this will be a new exhibit, which is going to be A3. A3, what do we want to call this? Photo with property line and setback line.
Correct.
So photo with property line and setback line, A3. And what were we trying to do here?
So this is the same photograph that we showed earlier. It's the view looking northwest along that common property line. what we did is illustrate the approximate property line in red, and then that 5-foot setback is shown in green. And we have a dimension in terms of what the length of the wall that does not comply with the setback. It's approximately 29 feet along this long way here, and then going in the side direction about 10 feet, going towards the pool.
Okay, so I'll call it the offending portion of the 3-foot wall is this stretch of 29.1 feet and 9.8 feet. That's the
Correct.
wall that we need the variance for. It was constructed in the wrong spot, and it violates, and that's the relief we're looking for.
Correct.
And if we wanted to comply, we could take that wall down and put it at the green line, which is the 5-foot setback line. Right?
Correct.
That would sort of make this wall complying.
Correct.
Okay, now, I think the question from a planning standpoint, do you see any benefit in terms of either structural integrity or benefit to the neighbor under this set of circumstances by, taking the wall down and moving it to the 5-foot, to the green line? Is it going to make a difference to anything?
Yeah, I would say it would make no difference. It's a no impact variance, whether it's like this or in conformance, there's no difference to the neighboring property owner. We described that vast landscape buffer, the grade differential, based on those factors. I would say there's no additional benefit to the neighbor to have a wall that conforms to that setback.
So, it could be done physically, obviously. You could get the masons out there and take it and build that wall to green line. But from a planning standpoint, you're not seeing how that would benefit the neighbor. Can we show the neighbor's house? We have a slide that has the neighbor's, what's back there for the neighbor.
This view here?
No, the one that has the fence sort of showing the side of the neighbor's property. I think it's photo 1. Yeah. So this is the side of the neighbor's house. Okay, and then you see where the tall trees start. So really you got, the air conditioning units over there and the neighbor's driveway, would you say?
Correct, yeah. And again, nothing from the neighbor's view to the subject property owner's pool and patio, you can't see it.
Okay. Chairman, the board expressed, legitimate concerns about what happened here and asked us to take a look at moving the wall. We went back. It physically can be done. It's a very significant expense. And I think that I would have advised the client to come in if there was some planning benefit, some benefit to the neighbor to move that wall. We're not seeing it. There is an unusually robust buffer here with a lot of trees. We would say plant more trees to mitigate, but that's not going to do anything. There's a grade change there. It's nicely landscaped. Those trees are above another wall, so you're talking about 20 feet. And it's next to the side of the house that has the air conditioning units and the driveway. So that's sort of where we ended up, and we wanted to come back to you to get your thoughts. We want to find a solution that seems reasonable, again, under imperfect circumstance, because obviously pulling out the pool and the spa is an extraordinary problem. So I want to try to see where the board's at and see what sort of makes sense and what the board can feel comfortable with under these circumstances. We do have the neighbor. I have not ever spoken with her, but I understand, and I'm making a proffer that she's not going to have great difficulty because that, it's sort of self-evident. Is she able to get here? Okay. If you'd be willing to open, I could call her as a witness.
Let's I guess, talk a little bit now, where we are. I guess I'll start on this one, and I'll let everybody chime in. I do appreciate the testimony and everything else. I still have this, I'm still stuck on, the pool's over 5.9 feet. The patio is 64% larger than what was approved, and now the wall's in the wrong spot. There was also the kitchen, which got approved, put in over the right-of-way for the storm sewer. I'm having trouble getting my head around stuff. I like to hear positive and negatively from my fellow board members. and see what
Chairman,
you guys think.
can I try to take the kitchen off
I know the
table?
kitchen's off. I
Because
just, yeah, that
we
was
have
agreed
that.
to, but it
There's
just.
no, that's not a zoning issue. That's an issue of the property rights of the right of way. and
Understood.
We haven't really resolved.
Yeah,
so.
no, I know, I understand.
And a permit
we
was
had-
issued. I don't want to cut you off.
No,
A
I
permit was
understand. We
issued
had a
for-
plan, and that was someplace else. It's just all kind of the picture to me, I guess.
I appreciate that.
But does someone else, anybody would like to chime in negatively, positively?
I just have just two quick things, just for clarification. The part that you have on here of the wall where you're saying that it's gonna be, that was on the property line, that'll be eliminated, and that's still on the table, correct? That you're gonna remove that?
Sure. And
If nothing else was done, that's what you're,
yeah, and actually, this is a good depiction of that. So the only encroachment is 1 foot, and it's at the corner, that far back corner where the retaining wall meets at a 90-degree angle, and there's just a sliver that's only 1 foot where the red line ends. That's going to be removed, so there'll be no encroachment onto the neighboring property.
okay, which then brings me to the next point. So the fence that's there in that picture is whose fence?
It's on the neighbor's property.
Okay.
And there's an agreement to use it, and you know, there's certain rules about swimming pools and maintenance
Yeah.
and all that.
Okay, I just wanted, just because that's another, you know, I know they're the owner today, and they might not be the owner tomorrow, and the owner tomorrow might turn around and say, hey, my property line's really here, because I'm going through it with a different neighbor on, you know, that I see, not my property, but with somebody else with the neighbor, and now they're moving their fence, realizing that they now have another 4 feet or 3 feet, they can move the fence over and make their backyard bigger, so, you know, which then that would impact the 1 foot you're talking about, which, because then the fence would have to be 6 inches in off of that line, so there's, you know, there's that. Is there any fence here besides what's on the property itself owned by the homeowner? Like there's the chain link, I see this fence goes into a chain link in the back, is that the Board of Ed's fence? Or,
I believe that's the homeowner's fence.
which is on the Board of Ed's property?
I mean, he has a pool, so he's got to have a fence around it.
That's why I'm just trying to figure out, because
You're talking
I-
about in the rear, can we tell Mike?
Yeah, it's part of it is off the subject property. That's correct.
It's, part of it's off the subject.
Todd, I
Mr.
did-
Chairman, I think I can clarify that. It is not on the boards, it's on the property owner's property,
Okay.
the fence.
Jackie, I just read it in the paper, I believe there was some arrangement between this property and the Board of Education. Maybe advise the board on that, so, with respect to that fence.
Well, okay, so the property owner, any pool has to have a fence around it. That's really boiling down to real basics. And I think Mr. Skolnick would agree with me that should the neighbor or the Board of Ed or whoever else other than the property owner remove any portion of that fence, his client, the property owner, would be obligated at that point to put up a fence. Otherwise, that would be a violation of the health and safety regulations of Livingston. But I think perhaps where Mr. Sherman was going, and you know, even Mr. Weissman, Skolnick, would your client agree as a condition of approval, should at some later point that the landscaping no longer be there in the section that your client has landscaping, that there will be a maintained landscaping buffer, regardless if it's on her side or your side?
Yes.
Their side and your side will be pronoun neutral.
We do have an agreement with the Board of Ed on the fence.
Okay.
I think so, Mr. Weissman saw it in the
Right,
paper.
so-
Recently agreed, I know that Township has some regulations about that, where if you could have a shared fence as long as you have an agreement, but if you have to have a pool, you have to take the maintenance rights.
Right, and I think, Mr. Skolnick, part of your application, your client's application for tonight relies upon the landscaping that's on the neighbor's property. So my point, and I think Mr. Sherman's point, is that at some later point, if that landscaping goes, the benefit of the landscaping is now gone, even though the property owner was receiving the benefit of, in essence, somebody else's landscaping. So that's what I'm saying. I think you would agree. I think you agreed with me. I think I heard that. That there would be a landscaping buffer maintained, regardless if it's this or if it's at some later point the property owner would be required to put the landscaping on her side or his side or whoever's side.
That's an agreeable condition and seems to be reasonable under this circumstance. Chairman, could we hear from the neighbor? Sure. Okay. I'm going to call her as a witness, Nancy.
Yeah, no, you just go right up to the mic, ma'am. Do you swear firm and tell the truth for the zoning board tonight?
Yes.
Okay, that was very quick. And you can please state and spell your name for the record.
Nancy Wolk, Nancy Wolk.
Okay, I'm gonna make a wild guess as to your address, but why don't you give us your address?
10 Hearthstone Terrace.
Okay, Mr. Skolnick?
Okay. You understand what's happening here and the relief? Can you give the board your thoughts?
Okay. I appreciate your concern about the impact on our home and our property. To be honest with you, I didn't even know what wall was up for debate. I think what they've done to the yard is beautiful. The house sat unfinished for a very long time, so we're grateful that they've put in a beautiful pool and a beautiful yard. I love how my trees look in the picture. Very pleased. So we don't have an issue with it. It's been very amicable. We don't have any concerns. The Brenners have been great neighbors. Everything that they've done, they've run by us, and we don't have any concerns.
Can I ask one? Do you think you'll get any benefit if the wall is moved to its, to the green line? Is that going to impact you in any way from where it is now? See the green area?
Absolutely not. I mean, I appreciate everyone, wanting to honor the setbacks and everything else, but we don't see their yard. We have huge arborvitaes that we put in when we did our pool almost 20 years ago. I can't see their yard. They can't see ours. I literally asked them, can you point out what wall we're discussing tonight? Because it's pretty irrelevant to us.
Thank you.
I have another question. So in terms of comparing the initially proposed impervious coverage versus the currently built impervious coverage, there's a significant increase in that the patio, which was supposed to be concrete, now pavers, is substantially large. There's a big slate patio with a fire pit in the backyard. I'm just concerned, have you ran the calculations on impervious coverage?
Yes, sorry, go ahead.
Yeah, just.
Well, we had to come up with it. This has gone through engineering, and of course, the municipality doesn't regulate impervious. The municipality doesn't, we comply, it's not regulated. We did have to expand the detention pits, and all that work's been done, right?
Correct, yeah, we
That's
were
been signed
proposing
off by.
another drywall to mitigate for the additional impervious coverage.
So we don't have, we don't violate anything in that regard.
Okay. And is there a reason that the retaining wall is short, not taller? Is it just for visual concerns?
It was designed with that height just to meet the existing grade and match the grade approaching the neighbor's property.
Mike, I'm sorry.
Yeah. And just going back to the kitchen, the placement of the kitchen, was this the plan that was submitted and approved by the building department?
The building department did approve the electrical aspects of the kitchen. So there was an approval for this kitchen work. It is on top of the right-of-way, It's not a zoning violation, so it's not in front of this board. We don't violate anything. We do have drafts of an agreement with the township attorney working out this issue, basically saying, if the town ever needs to get to the storm sewer pipe, we'll rip out the kitchen. It's on us to rip it out, and we can make that a condition of approval. So
Well, it's not, you can't make it a condition of approval because it's not a
okay,
variance before the board.
we
so.
have, I'm representing to the board that we, there were some problems here, and we're trying to make things right, and there was concern in the engineer's review letter about the kitchen location. I don't want to litigate that here because there was a lot of confusion about that because we got building permits for that aspect. And then the building department said, well, we're whatever they said, there's nothing to revoke. We got building permits.
But the kitchen's up before the board. Kitchen's
That's
up
what
before the board.
Well, Mr. Wenzel, your board member's raising it, and it doesn't look good for me.
At 9:30, I'm ruling the kitchen is not part of this, so
appreciate
let's
it,
move on.
But what I'm asking for is not to have a negative inference about that we did
And
something wrong
I'm
because of
telling the board
kitchen.
that, get right to the point, the kitchen is not part of this, is not part of the discussion, it's not part of the determination.
So long as, I think the board members understand that. We're fixing that issue, and I think we have a reasonable accommodation that the township committee will ultimately accept.
Okay. Any other comments from the board? Any other comments from the public? Okay. I think that's it.
That concludes. I would appreciate if the board, has some major concerns because we have this issue about the pool, and if the board, either needs more information or is not comfortable with what we're presenting, it's no D variance, so it's just a majority, but that it let us know because we want to try to find a way that makes sense for everybody here. But that's up to the board.
Anybody, any comments or?
I'll chime in my concerns, and could be persuaded by my fellow council members otherwise, board members otherwise. I'm concerned, and it looks beautiful, and it looks great. I feel like we're being asked to rectify a problem we didn't cause. And I'd really like it, on the one hand, it looks great. And it's great that I always like when the neighbors come out to support it, because that does influence. Here, I'm just concerned legally, because I look at it that it's irrelevant whether it's, I'm just looking at plans, and I think, unless my counsel corrects me, that I have to look at it, would I approve these plans based upon C2? Because I'm not sure I heard like the hardship. I don't know if I would approve this under hardship, and I have a problem saying that if these plans came and it wasn't built, that I would say, oh, sure, this is a substantial, this substantially benefits and outweighs the detriment of violating the zoning law. So that's the difficulty that I'm having here is what if it wasn't built? And I look at this, and that's maybe I'm using the wrong standard, and my counsel can advise me, but that's my difficulty. I probably would give this, like if it came before, the spa seems like it's a little bit, de minimis shouldn't count, but in this case, because it's up against the combination of de minimis and it's up against the school, probably I would. But I'm just telling, because you asked for what the concerns would be. It's the legal framework, the legal rationale would be.
Can I address that, Chairman?
Maybe counsel wants it first.
Yeah, no, that's fine. I mean, these are difficult issues because obviously, as Mr. Weissman has brought up, this is something that's already been built. So this is sort of baked into the consideration. I believe this is being presented as not as a hardship because the hardship is not. This has not been I'll let Mr. Skolnick speak on this, but I think it's more along the lines of C2, a flexible planning alternative, and that's what Mr. Roth, I think, testified to last time. He was kind of testifying to again as to today. Obviously, you've heard the testimony from the neighbor who has indicated that, you know, the impact to her, that the impact to her was, I'm putting words in her mouth, minimal to almost non-existent. I'm not even sure she knew what was, not that casting aspersions, but not that she didn't know what was going on, but that was unnoticeable to her. So, you know, when you have some degree, and I'm not sure which board member said this, but some degree, it's almost better when something is built so that you actually have the real life experience from that person, of the neighbor in this set of circumstances, to be able to say, oh, well, there is no impact to me. So when you go to that negative impact that Mr. Roth speaks about, you have a person who's saying, I am the person who would be negatively affected, and I am saying there is none. When Mr. Roth spoke about the points with regard to the positive criteria for the C2 variance. So you have the option to grant that. You know, obviously council indicated about the efforts they went through with regard to looking at this again, and making that determination. But yeah, you have the ability to approve this under what I would term a C2 variance.
I'm going to ask that you look at it like this, that the C2 is a weighing and a balancing. And when the negatives are so small that you don't need a lot of benefit, you don't need that. And we heard from the neighbor. I think you see it yourself. And you heard from this is what you might call a no detriment or virtually no detriment case. So the detriments are very low. Under that circumstance, we don't need that much benefit. And we have the benefit of sort of an appropriate pool, a beautiful backyard, beautifying the area, an appropriate place in a nice neighborhood for a family that has a pool. So we have some benefit. It's not, we're not changing the world, sort of, you know, it's not an inherently beneficial use by any means, but we have some benefit, but we have very, very low detriment, and it's up to you to sort of weigh that. I also think you may have the test a little bit wrong. It's not that we have to substantially outweigh, it's can the variance be granted without substantial detriment? That's the way I understand it. I don't have my Cox book tonight, but I think I always bring it, I didn't bring it tonight. But I think at least one of the tests, can you grant without substantial detriment? So there's always some detriment when you don't meet the requirements of the ordinance. But here we're talking about a 3-foot wall for a length of 29 feet by 10 feet. And I thought that this exhibit is really very good because we could legally build the same 3-foot wall along that green line. And what's that going to do for anybody at this point? I know that the board does not like getting these cases because I had 24 Bryant and I had the case that you just heard. That was a different set of circumstances and perhaps different culpabilities. And now you have this one. I know that it's a very difficult position for the board to be in, to get presented with after the fact requests. I get that, my client gets that. I think that if there was anything we could possibly do that would make any sense to increase the benefits, but it's really only more landscape. We can add some trees towards the front. We don't have a problem, but look at this barrier that you have here. It's a grade change with a wall, with mature 15-foot trees in the neighbor's backyard. I just don't, that's, what I'm offering on the C2. When that detriment is very, very low, you don't need much benefit to sort of outweigh. That's the request. Those are the facts we're presenting.
I don't disagree with anything you said. I guess I'm still a little hung up because original plan at 6 feet off the pool, and even forget moving the pool, now we got 11 feet off the pool, which is why the wall had to be there. So it's like how do we get here, and how do we get ourselves out of it? And that's where I'm personally hung up on. There's there's a bunch of moving parts, and if it was just like, it got built a foot over by mistake and everything, like, oh, all right, things do, yeah, it's just, I'm having trouble wrapping my hands around it. I still, a few people have not commented. I think we need to give Mr. Skolnick a little bit better idea of where everyone else stands, so if people want to chime in.
Sure, I'll chime in. I mean, would I have approved this if it was coming to us pre-construction? No. Right, I would have said, meet the rules, right? I appreciate the fact of it's done, and obviously I don't know every little detail that happened. It doesn't appear to have a massive negative impact to the neighborhood or to the environment that I can tell. I would be adamant on the condition as stated before, that should those trees, which are not yours, on the neighbor's property come down, and I have the exact same thing on one side of my house, that you would be required to put that up, because again, while you two get along great today, we don't know who's gonna own this house in the next 3, 5, 10, 20 years. As long as you're okay with that condition, I can get my head moving forward.
I think it looks like you are making a motion to approve with those conditions. I think we should move on.
There's more comments, there might be more comments.
I'm just trying to get to the end zone, man.
Look, let me just roll back here a second. The board's role, and it's always wonderful for the board to give its insight, but obviously the board's quasi-judicial, and you don't get advisory opinions from the court, you don't get advisory opinions from the zoning board, so when an application is presented, absent comments in favor or against a application, the board should really vote.
I am fine to make a motion to approve based on the condition as stated before regarding should those trees no longer exist, that you would be required, or the homeowner at that time, to put up appropriate barriers. That would be my motion to approve.
Does anybody second?
I'll second it. Okay, Mr. Horn.
Yes.
Mr. Kenya, Mr. Shaw,
Yes.
Mr. Sherman.
No.
Okay, Mr. Wiseman.
No.
Okay, Ms. Sohel.
No.
Mr. Beer.
No.
Okay, we got 3 yes and 4 no's.
The motion doesn't pass.
Motion doesn't pass.
Okay, thank you for your time.
Please, you need the internet?
Devonshire's next.
Devonshire.
Okay, block 7105, lot 1, 15 Devonshire Road, application number 2025-58-V, Robin F. Lewis and Robert Sepoff. Applicant seeks approval for an addition in violation of the following section: 170-96C2, front yard setback 75 feet required, 68.16 proposed, 6.8 feet variance requested.
Well, yeah, I hope so. So I get some hourly rate. I'm losing it, Jackie. Okay.
Hi there.
Good evening.
Good evening. Almost morning.
What's that?
It's almost morning.
Yes, well, I think this one hopefully will be the shortest one of the evening. My name is Michael LaParry. I am a partner with Mandelbaum Barrett. I am counsel to the applicants Robert Sapoff and Robin Lewis. They are the owners of 15 Devonshire Drive. The house is located in the R1 Residential Zone District. We are here before you this evening seeking a C variance to allow the homeowners to construct a very modest addition of approximately 168 square feet to use the addition as an expanded laundry room, powder room, and expansion to the pantry. The variance is for a front yard setback where 75 feet is required. Currently, 68.67 feet is existing, and 68.2 feet is proposed in the area of the addition. So the variance is for about 6.8 feet. Currently, about 6.3 feet exists along that front yard setback. The house itself has been existing since 1966. It's conforming in all other respects. Just to get an idea of how modest of an expansion this is, the R1 zone permits a floor area ratio of 15%. And if approved, this applicant would be at 7.32%, which is less than half of what is permitted. The permitted impervious coverage in the zone is 30%. The applicant would be at 17.32. I bring that up only to just get an idea of what we're looking to do. It's really a very small expansion, sort of squares off the house. So part of the reason for the deviation is that the house is not exactly parallel with the street and the lot line along Devonshire. So the setback line, in order to keep the house, to sort of make the house continue the straight line, we have to do a slight encroachment on that side of the line where the expansion would be. Again, it's very modest. We'll walk you through it. What we hope to do is ask for the relief rather than beg for forgiveness after the fact. Hopefully you guys will appreciate that. We have a couple witnesses with us tonight. We have the homeowners, on behalf of the homeowners, Ms. Robin Lewis, who's just going to give a brief statement, and then we have our project architect, Corey Fernandez. So unless there's any questions, I'll just...
Okay. Who do we got first?
Ms. Lewis, yes.
All right, Ms. Lewis, do you swear affirm and tell the truth for the zoning board tonight, so help you God?
I do.
Okay. You are the homeowner, Robin Lewis, correct? All right, go ahead, counsel.
Yes, thank you. Ms. Robin, if you could just please just give an overview about who you are, what you're trying to do at the
Sure.
at the house.
Absolutely. My husband Bob and I have lived in town for over 30 years. We lived in Broadlawn. And as we got older, we decided that it would be a good idea to lose steps from our life. And so we started looking for a ranch, which, as I'm sure you know, are not easy to find these days. So it took us over a year. We found a wonderful house on a wonderful piece of property. And we were thrilled because we want to be able to stay in town, age in place, stay in our home, and continue to be in town. The house is wonderful, but there are two things that sort of make it a little bit difficult for us. The laundry room, as Mike said, it's not really a laundry room. The washer and dryer are basically in the entranceway from the side, from the garage that walk into the house. So the machines are there, but there's really no room to do anything or to even hang anything. And then the other area was that there is no half bath or powder room. And so we wanted to include that in this small addition so that guests would not have to go into the sleeping area, to use the bathrooms of visitors or guests who are there. So it's a small addition, but it would just help to make our home even more better than it is for our next 30 years, at least we hope.
That's all I have, Ms. Lewis. If you guys have any questions, we're happy to answer them.
Does anyone have any questions for this witness? Does anybody in the public have any questions for this witness? We're good.
Okay, thank you.
Thank you. Then at this time, I'll call my next witness, which is Corey Fernandez.
Fernandez, do you swear affirm and tell the truth for the zoning board tonight?
I do.
Can you please state and spell your name for the record?
My name is Corey Fernandez. That's CORYFERNANDEZ.
Okay, can we have your qualifications briefly?
I'm a licensed architect in New Jersey, been licensed since 2016, got my education here in Newark, NJIT, and I own a practice total architecture, presented before other townships, neighboring communities in New Jersey.
Does anyone on the board have any questions or objections regarding this witness? There being no objection, the witness is accepted as expert in architecture.
Thank you.
Thank you. Mr. Fernandez, if you could just briefly walk us through the plan, and if, while you're doing that, if you could just maybe just quickly identify some of the issues with the lot line, the location, the corner lot, et cetera.
Sure. So the house is on the corner of Devonshire and Hobson. It's a corner lot, which typically means you have two front setbacks. In this case, there's a side front setback, which is a little less restrictive than the front setback. But facing Devonshire, the setback would be 75 feet. The existing house is non-conforming, so whereas 75 is required, 68.67 is existing. Our proposal is 68.2, so we're looking for what's essentially 6 inches more of an encroachment than exists today on the Devonshire Road. The Hobson side road, no variance is required. It's within the setback. Okay, site plan. There's no page down. Let's do it. I swear I use a computer all the time at work.
I think it's just architects.
Yeah.
We were doing
I
so
just want
good,
to change
too.
the page.
We were doing so well.
How do I change the page here? Maybe I can do it this way too. Oh, here we go. Let me just open up a new set of plans.
He's dressed wrong, that's
Got
why.
it.
He's dressed with a tie and the jacket.
Okay. All right, so here we're looking at the existing plan. I got this figured out now. We're talking, this is the existing laundry room that the applicant has discussed, so very small, not enough room. So we're looking to expand this corner of the house. So I'll get into the new plans. That is the basement plan, so this addition will be over a crawl space. The extents of the addition are 14 by 12. It's 168 square feet total. This is the proposed addition with the larger laundry and a half bath. We have some space left over, so we're going to use that as pantry space for the kitchen. And just to back up what the applicant said before, the only other bath that a guest would use is on this side of the house, which is the sleeping quarters of the house, whereas more the entertainment, public side of the house is towards the Hobson side of the property.
And just real quick before you change, that plan, just for the board's understanding, the addition protrudes even less than what's existing there?
From an orthogonal perspective, yes, right? But the issue is that the house is set, it's not set parallel to the property line.
Right. So that's why there's an additional 6 feet that's being requested, 6 inches,
6
I'm
inches,
sorry.
correct. This is the roof plan, so everything not hatched in there is existing, and then that's the roof of the proposed addition. The top view is a 3D view, so this portion right here is the addition. Generally, I feel it's keeping with the character of the existing home. We're matching the materials, the shutters, size and shape of the addition, and the slope of the roof, so it ties into the house nicely. And
So it'd be fair to say that the only change is that the addition goes out an additional 6 inches?
6 inches
Right.
than what's
correct?
existing.
6 inches closer to the lot line, but as far as looking at it from an
Right.
aerial, it'll stick out less than what's existing.
Right.
On the other side of the house.
Okay.
And Mr. Fernandez, do you see, once this is built, if it's approved, would it be something that would you'd even be able to tell after the fact that this was, an addition was put on, or would it look like it was part of the original plan?
It'll look like it's part of the original. There's no substantial detriment to the neighborhood. It's in keeping with the character of the neighborhood, size and bulk and character of the neighboring homes, and the size and character of the existing home as well. So that concludes my testimony. If anyone has any questions.
Okay, I'll just ask one quick question. The habitable floor area is 7.32%. That's based on the 41,000 square feet, plus or minus. So this was, if you even calculated it as a regular sized lot for this area, you'd still be way under the habitable floor area, right? Not like, I
Less
got
than
like
half.
8.6%.
Yes.
So it's not even close, right? That's all I got for clarification. Anybody else? Anybody in the public have any questions? Anybody in the public have any comments? Would you like to make a closing statement?
I think, you know, in my questions, it's pretty obvious, this is a very modest addition. There's really going to be no impact to the neighborhood, no detriments that anybody could foresee. It's just really going to allow extra utility for the homeowners, as they stated. We think this is probably one of the easier ones, hopefully, fingers crossed. But I think this would be a good approval, a good addition to the neighborhood, and we would just ask that you approve.
Would anybody like to make a statement? Would anybody like to make a motion?
I'll make a motion.
I'll second.
It's too slow. Mr. McKinney and Mr. Horn?
Yes.
Mr. Shah?
Yes.
Mr. Sherman?
Yes.
Mr. Wiseman?
Yes.
Ms. Sohel?
Yes.
Mr. Beer?
Yes.
Motion carries.
Congratulations.
Congratulations.
Thank you very much.
Thank you.
Thank you.
Okay.
Okay. Gaining speed.
Gaining speed, gaining speed. Okay.
Okay, good luck. Cambridge is
Block,
out.
no, Cambridge is out. Next one, Cliffside. Block 301, Lot 26, 6 Cliffside, application number 2025-6-V, Iconic LLC. Applicant seek approval to construct a new single-family house in violation of the following section: 17097C2, front yard setback 60 feet required, 51 feet proposed, 9 feet variance requested. 17087CC2, habitable floor area ratio 18% allowed, 19.5% proposed, 1.5% variance requested.
Okay.
Good to go?
You're up.
Good evening, Mr. Chairman, members of the board. Adam Lazarus of Prime Tuvel and Maselli on behalf of the applicant, Iconic LLC. Since it's almost 10 o'clock, I'll skip my 30-minute intro and just get straight to it. As you've already mentioned, the address is 6 Cliffside Drive, Block 301, Lot 26. We are in the R2 zone. This is an application to build a new single-family residence on the property. We do have 2 variances, as mentioned. The front yard setback, where 60 feet is required, we are proposing 51. And for the habitable FAR, we have allowed 18% and are proposing 19.5. We have 2 witnesses. We have the project architect, Eamon Cedra, and our planner, Nick Graviano. And with the board's permission, we'll let the architect begin his testimony.
Okay, Ms. Cedra, do you swear affirm and tell the truth for the zoning board tonight, so help you God?
I do.
Ms. Cedra, you're qualified as an architect before this board on many occasions, yes?
Yes.
And your license to practice in architecture is still valid?
Correct.
Okay, Chairman?
Does anyone on the board have any questions or objections regarding this witness? There being no objections, the witness is accepted as an expert in architecture.
Great. So, Mr. Cedra, if you can, let's just jump straight into the proposed floor plans to get
Sure.
things moving.
So this is a single-family house, as it's known in Livingston. We design it kind of like in a similar way, where we have the living spaces at the first floor, and we have the sleeping area at the second floor. The basement, it's just open space for recreational. And also we have a 3-car garage at the basement level as well, accessible from the side. The total floor area ratio is 4,863. The habitable floor area is 19.5, so we're asking for 1.5%. We put the building at 51 feet as our front yard, and that will keep it with the neighboring properties. We did a study for the neighboring properties where we got the average front being 50 feet, 0.5. Also, I would like to mention that the existing structure was located at 50.3 feet. I would like also to mention that we have an open space at the second floor, which is counted twice. This is the front foyer where we have the stairs. It's counted twice, but only used at the first floor. And we also, as part of the floor area ratio, we included the excess of the 450 for the garage space, which is 362 square feet. It was counted toward the floor area ratio.
So, I mean, just to, kind of go back here a little bit quickly, the front yard setback, which you mentioned, the existing house is at 50.3 feet. You did a study of the prevailing front yard setback on the streetscape, came to 50.5 feet, which is why we're proposing the 51 instead of 60. So our house is not out of line with the existing houses on the street.
Correct.
Is that correct?
Yep.
And as far as the habitable floor area ratio, you mentioned that we're at 4863 total square feet, which is under the permitted maximum of 4870. So we do meet the compliance for the square footage maximum. As far as the ratio, you said we're over by 1.5%.
Correct.
And you mentioned that we do have a basement garage, which is a 3-car garage, which has 362 excess square feet over the permitted 450. And that 362 makes up the difference of the 1.5% we are seeking tonight. Is that correct?
Correct, yes.
Okay.
The design of the outside is a colonial style home with stucco facade and stones. We have some stone at the base and the entrance of the house, and also it has some modern accent where we have casement windows, and also we'll use, the owner likes to use white stucco, and maybe the roof will be a black asphalt shingle roof. This is the rest of the exterior here.
Yeah, so, I mean, I know it's late, we're going to move things quickly. Just the last question, really, to hammer this home. If in that basement space, instead of providing a 3-car garage, we did an additional basement bedroom or rec room, would we comply with the FAR requirements?
Correct, yes. If we take this extra 362 square feet and we used it toward either storage space or any other space in the basement, rec room, wherever, eventually, yeah, we don't really need that variance.
But we felt it was better to provide more off-street parking.
Yes, exactly.
Right, got it, okay. I'll turn it back to the board then.
Thank you. Does anyone on the board have any questions for this witness?
Yes, I do. The second, the 2-story foyer that you are saying, it's counted twice. I mean, that's the zoning regulation of Livingston.
Correct.
So I think it should be counted. I don't think that should be.
It is counted.
Right.
It
should not be
twice.
presented, right.
Yes.
Correct.
But it's only used from the first floor because there's no floor above.
Yes, and that's what Livingston does. In terms of the garage, again, Livingston does require garage to be attached to the homes or off-street, on the property premises, parking be provided. So I think that is also in performance. Want to make that note.
Sure.
Anybody else have any questions or comments? This was?
Yes, I don't know if this is the question for you or not, but what are the hardship that you are facing on this property? And I see that you have a deep lot. Why can't we have the house set back to the setback line?
We have a severe,
the planner have?
yeah, the
You're going to
planner
have Mr.
testify.
First of all,
to
you're
that.
going to have Mr. Graviano testify. You're beating Mr. Graviano to the punch. He's gearing up, ready to tell you all of his important information. But also, remember on the front yard, I believe what you had indicated is that, as it is common in Livingston, there's the average of the homes in the area, and I think also Mr. Graviano is going to speak to that, that on the averaging of the front yard.
Correct.
Nobody else on the board, any questions? No. Anybody in the public have any questions for this witness? Okay, I think we're good.
He's better off there, trust me. Do you swear for and tell the truth for the zoning board tonight, so help you God?
I do.
All right, please state and spell your name for the record.
Nicholas with an H, Graviano, G-R-A-V as in Victor, I-A-N-O. I am a planner and partner with Graviano and Gillis Architects and Planners.
And Mr. Graviano has been qualified as a planner before this board on multiple occasions. Mr. Graviano, your license has not changed since last week. It's still valid?
Still valid, yes.
Okay. I don't know if you had any other changes to it. All right, so, Mr. Chairman,
Does anyone on the board have any questions or objections regarding this witness? There being no objections, the witness is accepted as an expert in professional planning.
Thank you, Board. Always a pleasure being here. I'm going to keep this brief. It's a pretty simple application. The applicant's before the Board tonight requesting relief for a specific piece of property known as Block 301, Lot 26. That's a street address of 6 Cliffside Drive. This is a 25,000 square foot lot. As Mr. Shaw indicated, it does have some depth to it. However, the depth in that yard, when you get into that backyard, is a slope. So the front yard setback variance relief actually has two purposes. One, it meets the intent of the front yard setback averaging as permitted in the ordinance. I would like to note that the property to the left and the property to the right are set back at 50.7 feet. The applicant's coming in here at 51 feet, requesting that 9-foot variance. But the second prong of requesting that variance relief relates to the fact that there is a pretty considerable slope in the backyard. Having the house at that 51-foot setback does allow for the home to have a little bit of yard space before you hit that slope, and you'll see that in the plans that were provided before the board this evening. So in the sense of that variance, the front yard setback variance, I would say that relief could be granted under both the C1 and C2 criteria, whereas relating to the C1 criteria, there is an exceptional topographical situation affecting the specific piece of property. Strict application of the zoning ordinance would create a situation where the applicant's backyard was a slope. That also creates problems in terms of drainage with the slope draining straight to the house. So this is a rational design for the dwelling. Additionally, variance relief can be granted under the C2 criteria where hardship need not be demonstrated. What must be demonstrated that it relates to a specific piece of property. Here you have a property with a slope condition, and certainly giving that 9-foot front yard setback variance, which is the neighborhood norm, would certainly promote purpose I, promotion of a desirable visual environment, creative development techniques, and good civic design and arrangements. Looking at the other variance that the applicant's requesting before the board this evening, that is a D4 FAR variance. As the board knows, with respect to the FAR variance, the applicant must demonstrate that the site can accommodate the proposed use, withstanding the request for the increased FAR variance. One of the positives of this application is that the applicant is increasing the aggregate side yard setback from 54.6 to 60.5 feet. The applicant is below the habitable floor area square footage requirement. Additionally, this zone permits 20.73% building coverage, whereas the applicant is coming in at 11.3%. And then lastly, this zone allows a side yard setback of 15 feet. The applicant has side yard setbacks of 25.6 and 29 feet. So it's certainly a situation where the site can accommodate the proposed use without any substantial impairment to the zone plan, zoning ordinance, or the public good. Additionally, I had a chance to visit the neighborhood on 2 separate occasions, as well as look at the tax records, and the square footage of this house is certainly in keeping with the established character of the neighborhood.
And just to add on to what you were saying, so as far as let's work backwards, the FAR variance, we meet all the bulk standards for the zone. Our house is within the acceptable setbacks, height, building coverage requirements, and the additional FAR is going to be in the basement underground. Therefore, the site can accommodate the additional FAR ratio without imposing on the streetscape of the neighborhood scheme. Is that correct?
That is correct. I would just like to know we are requesting a front yard variance relief, although we are meeting the averaging requirements of the ordinance.
And going to the front yard setback you just mentioned, would you agree it's a better planning alternative to meet the prevailing front yard setback, stay out of that rear yard slope, than it would be to meet the 60-foot requirement of the zone?
Well, I think it's certainly appropriate in certain conditions to have deviating front yard setbacks, but I think the main concern here is the topography and slope in the rear yard and giving the home a usable rear yard space.
Does anyone on the board have any questions for this witness? Please.
Yeah. So Livingston allows the front porch, only 6 feet of the front porch and steps to encroach into the front yard setback. The way this is drawn, proportionally, it looks like it's more than 6 feet, so I would like you to reconsider the 51 feet and maybe look into the 6-foot porch variance that Livingston allows.
Eamon, how many feet do we encroach into that?
I'm just looking at it. So I have exactly 6 feet, 4 foot and then 2 steps. We're allowed 6 feet, right?
I mean, we can make a
Okay.
condition of approval that will meet the 6-foot requirement.
Okay, any
I'll
other?
make that,
Oh.
yeah.
I just have, I would assume you testify that also in the back, you have these large evergreen trees that have been there many, many years, that I think if you pushed it back, it would require perhaps cutting down some of those trees that we wouldn't want. Is that correct?
The applicant's proposing the house to minimize disturbance on the slope.
Thank you.
Does anybody else have any questions for this witness? Although, I guess it's Mr. Cedra, the attic is not usable, correct?
Correct. The attic it's only have pull-down stairs.
Okay.
And there is no windows in the attic level anyway.
Okay, so condition of approval, that's not a problem then, right? Okay, anyone in the public have any questions for this witness? Please come up. Oh, one second, he got to do his job.
Do you swear affirm to tell the truth for the zoning board tonight, so help you God?
I affirm.
Okay, and sir, can you please state and spell your name?
Name is Stuart Levitch, Stuart, last name Levitch.
And address?
60 Bryan Drive. I'm here for a different application, but it may apply to this one. I was just curious, what's the depth of your basement from ground level? If I can ask.
You mean the height
From
of
the, no, I'm talking about for the excavation, to put the basement in.
We're going down.
Well, let me just say, you don't have to answer that. The reason I'm up is, like Ed, I'm a New Jersey PE here in the state, and I have a concern by watching all the construction going on with these houses, that the basements are going in beyond 8 feet, and there's no supports. And from what I understand, there's nothing on the plans that references the OSHA regulation for putting in, for excavations.
So
Okay.
let me say this. So anything with regard to OSHA, building subcode, any of those pieces, those would all be dealt with by the engineering department and then code enforcement. So this board doesn't necessarily have jurisdiction over that issue.
Okay.
Other than, I'm not saying it's not a valid issue, obviously. It is a valid issue, but it's really a valid issue at the time at which the applicant provides their as-built and more finalized plans for submission to the engineering department. So I think the applicant should take that information to heart in terms of finalizing their plans, make sure that they're compliant.
Because
And
there is,
obviously the
there is an
engineering department-
exception to the regulation. And-
Well, yeah, and I think at the end of the day, that those very valid issues are not jurisdictionally before this board.
Okay, because I brought it up because I read the soil removal permit article, and there's no mention in it to as far as, complying with.
As counsel said, supportive excavation, stuff like that is not our purview. So,
Okay, no
Yeah,
problem.
but you can go to the engineering department anytime and discuss
Okay,
with
yeah,
them.
I'll have to speak to Jeanette then.
Yeah.
Okay.
Thank you.
I'm showing the applicant submits their construction drawings drawings to the building department, all regulations.
Okay.
Thank you. Does anybody else have any questions or comments for this witness? Okay, back to you.
Yeah, just to sum up very quickly, you've heard our planning testimony, architectural testimony. I believe we met the burden of proof both for the D4 FAR variance as well as the C variance for the setback. The benefits outweigh the detriments as regard to the relief being sought. And we hope that the board agrees and will grant approval.
Does anyone on the board want to make a statement?
I'll just say one thing. I just wanted to say that even if you took out the front yard setback out of the equation, the house, then you're just talking about the footprint would fit that you would be allowed to build on the site. You're then just down to a 1.5% floor area ratio in reality. The other thing, as you pointed out, is that the garage, yes, gets counted, but in theory, that third car garage could have been just basement space since it's on the basement level and wouldn't be counted. That's about 220 some odd square feet, and now you're down to about a 0.6% above the, for the ratio. So, with that being said, I would make a motion to approve, subject to the condition for the attic won't be habitable living space.
Seconded.
Way to go, guys. Mr. Sherman?
Yes.
Mr. Horn?
Yes.
Okay, Mr. Kania, yes. Mr. Shaw?
Yes.
All right. Mr. Wiseman?
Yes.
Okay, Ms. Soho?
Yes.
Okay, Mr. Beer?
Yes.
Motion carries.
Thank you very much. Have a good night.
Okay, block 2800, lot 6.01, 423 South Livingston Avenue, application number 2025-53-3, George Reinhardt. Applicant seeks approval to construct a new single-family house in violation of the following section, 170-99C4, rear yard setback 35 feet required, 22.28 feet proposed with that's existing, 12.72 feet variance requested.
Wait, hold on a second. Hold on one second.
You made fun of me when I stood up. Oh, they're starting to circle the wagons. They're coming up further on us.
I'm sorry, Mr. Posada, I know you're all amped up, ready to go.
You know it. He actually finished already.
Okay. All right, sorry, Chairman.
No, of course. Mr. Posada?
All right, good evening, my name is Matt Bassam from Law Firm Thomas and Gross, and I represent the applicant, George Reinhardt, in connection with this application.
Hold on one second. We're okay? I'm sorry. Okay, you're good, Matt.
All right. In connection with this application for a rear yard setback, for once, we are not requesting a ratio or floor area, but just rather a simple rear yard setback. Reason being is because of the subdivision we had gotten prior. You'll hear from our experts here today that the site itself is pretty tight, but nevertheless, we believe that we're making a vast improvement to what was actually existing there before we took on this project. For tonight, I will unfortunately or fortunately have 3 witnesses. I will have an architect, an engineer, and a planner for this robust improvement. If I may, I'd like to call my first witness, Mr. Peter Serpko, my architect.
Okay, do you swear affirm and tell the truth for the zoning board tonight, so help you God?
Yes, I do.
Okay, can you please state and spell your name for the record?
Peter Serpico, Peterserpico.
Okay, and Mr. Serpico, I think you've been qualified here as an architect.
Yes, I have, several
I knew
times.
I recognized you. Okay, and your license to practice as an architect in the state of New Jersey is up to date?
Yes, check my email.
checked your email.
I'm getting good at this.
As an architect, he has a permit to wear a tie.
Yes, architects wear ties. Well, eventually we'll get Mr. Graviano to wear a tie.
Good
Although
luck.
That would be very unusual.
Yeah.
Go ahead.
Can you just,
want a sweaty mess, you don't want that.
can you just remind us of where your education was?
NJIT, graduated in 1986, been practicing for over 28 years in the state of New Jersey, licensed.
Excellent. License in good standing?
Yes.
Does anyone on the board have any questions or objections regarding this witness? There being no objection, the witness is accepted as an expert in architecture.
Peter, why don't you walk us through what we're proposing here tonight?
Sure, thanks. Okay, this is, there are actually two houses on this property. This is the second house. The other one has been approved. And I pretty much designed this, it is a modest home, size-wise. I went with the diligent work of Casey and Keller in terms of the FAR, and I worked off the setbacks that were required for this variance that we're trying to achieve this evening. So we'll start at the main floor. We've been talking about FAR all night, so let's do it again. Each floor, basement, we're not counting. First floor, 958 square feet. Second floor, 958 square feet, all within it's the exact maximum number that we're allowed for this property. Basically, entering this home, we have a North Livingston Avenue. Is it South Livingston or North? South Livingston Avenue. Front entrance, side entrance, garage that's on Plymouth, and the owner will have a nice little mudroom entrance from the garage and also his main entry from South Livingston Avenue. Walking through the house, or let's start at the porch. We have a wraparound porch which does not exceed the limits. We are 5'2" on the front, both front yards, 5'2" on this front yard. It's a little tight. We have a fireplace that extends out of the great room, but I kept a minimum 3'4" passage to clear that. Coming into the house, we have a nice switchback stair, open to above, office, powder room, open floor plan, great room, dining room, and a kitchen, pantry for storage, and the mudroom that you would access from the garage. Going down to the basement, by the way, this is a precast, Northeast Precast will be doing this work here, 10-inch walls, precast walls. We will fur this all out for any of those space that is living. We have a family room that's a living space, a bath, storage, and a bedroom. Mechanical room will most likely not get any furring on the walls. The house dimension is 40'11" by 23'5". Again, a modest size that I really worked with. I worked with the numbers that were given to me from the site plan that Casey and Keller developed over the last year. Second floor, nice 3-bedroom home, real simple. Bedroom 1 would be considered the master bedroom, walk-in closet, master bath. Bedroom 2, small bedrooms, but 9-10 foot each by 10, 11 by 11. Washer dryer on this level. Nice master bath in the ensuite. Garage roof. Let's go to the some of the elevations. Again, real simple. South Livingston Avenue, wraparound porch. You see the fireplace chimney. The owner does request a wood-burning fireplace, Mr. Reinhardt. Siding, we didn't decide yet, but George Reinhardt has built a few homes in town. Kind of likes going with some decent hardy plank. We haven't decided on color or any of that sort at this point yet. The right side elevation, this would be the rear yard, kitchen window. This is a dining room window. This is the staircase. There's still some talk about adding windows in the staircase. Gets a little tough with the difference in landing, so it most likely will not be added to this design. Left side elevation, this is Plymouth. which I think is a nice, simple elevation with the wraparound porch, two-car garage, a little narrow, but sort of a 1.5, 15-foot wide by 15 deep. This is that's the left side rear elevation. This is the side view of the view of the garage. A little peek at the fireplace chimney, and here's the gable roof of the main house. The attic is not habitable space. There is a pull down, and there is a slight cathedral. Did a small cathedral design in the second floor bedroom. This portion here will have a vaulted ceiling that will take on the roof slope from the attic. So this one portion of the attic will not be usable at all for storage. And the stair is not on this plan, but it's right at the front entrance here to pull up stair. I think that's about it. Again, conformed with all the Livingston zoning, R4. Again, worked off of, really designed this house from Casey and Keller's work on setting this up for this variance.
Just to clarify for the record, you originally said that this is the second improvement on this lot. You're getting confused from the subdivision, correct?
Yes,
This is the only
yes.
single-family home on the lot?
Okay, so you can, thank you. Thank you. I shouldn't have said any of that.
No. You were rolling, man. Yep,
Thank you.
you got it.
Does anyone on the board have any questions for this witness?
Can I ask a question? Okay.
Please.
I just wanted to clarify myself. You said that there are 2 houses on this lot?
Well, Matt,
Yeah, it was a subdivision, okay. And then second questions I have that the setback that you are proposing 12 feet into the, towards the Livingston Avenue. It's out of proportion with the neighboring house, so do you have any?
If I may, I'm going to have 2 other witnesses, and they're both going to put testimony on the record regarding that setback variance relief.
Okay.
Yeah.
yeah, thank you.
Does anybody in the public have any questions
I
for this?
have
Oh, I'm
another,
sorry.
sorry
I
about
didn't see you.
the wraparound porch, how high is that off the ground?
Off the ground, I'll give you an estimate. I probably don't have a dimension on it, but
2 feet?
this is 2 feet, 7, so it's 9, 10, 11 feet. I would say.
Sorry, like off the,
Would you say it's approximately 2 feet?
2
The
feet off the
porch?
finished grade?
Off the
Of the
finished
grade?
grade?
Yeah,
Yes.
2
of the
feet.
grade, yeah.
And a 7-foot height to the underside of the beam, and then another
I
2
was
feet
just
for-
concerned about the floor where people would be walking, because 2 feet is significant height. Are you concerned about them falling? I didn't see any
Most
rails.
likely, I actually looked at that today. We most likely will have railings on that. The reason why, the owner originally wanted to grade this a little higher and have it with the one-step drop where you wouldn't need railings, but I think as it changed, these drawings were already submitted. But yes, good point. Anything more than 2 steps would require a 36-inch high railing. So for the record, I think we can say we will have railings on this porch. Thank you.
Okay. Anybody else on board? Okay, anybody in the public have any questions for this witness? 1 down, 2 to go.
Terrific. I'd like to call my next witness, Mr. Mike Lanzafama, as my civil engineer and surveyor.
Thanks, Mike.
All right, Mike. Where's my drawings? Oh, here we go. Oops.
Okay, do you swear, oh, you got ready. This is a hardcore professional. Do you swear affirm and tell the truth for the zoning board tonight?
I do. My name is Michael Lanzafama. That's Lanzafama. I'm a licensed professional engineer and land surveyor, licensed in the state of New Jersey. I'm a principal with the firm of Casey and Keller Incorporated, 258 Main Street, Millburn, New Jersey. I've testified before this board on numerous occasions.
Does anyone in this board have any questions or objections regarding this witness? There being no objections, the witness accepted as expert in civil engineering and survey?
Correct.
Yep.
Yes, our office was engaged to prepare the original subdivision plat that went before the planning board, in which this lot was a portion of that subdivision. The lot that was created is 6,389 square feet. It's located in the R4 zone on the southeast corner of South Livingston Avenue and Plymouth Drive. The proposal is to construct a new single-family, two-story home on the property. There will be a one-car garage on the southeasterly side of the structure, which projects into the required rear yard for the property. The building itself will meet all of the setback requirements with regard to the front yard setback. A side street setback variance was granted as part of the subdivision approval, and we will be maintaining that variance setback of 15 feet as it was approved. The porch does extend into that area, but that is permissible under the ordinance. The combined side yard requirement is met. It's well over the 30% that's required. It's actually over 53%. The variance we're seeking is the 35-foot rear yard setback that's required. That's the lot line that is opposite South Livingston Avenue. Chairman Shaw, or Planning Board Member Shaw, or Zoning Board Member Shaw mentioned that it's a front yard variance that we're seeking. It is not. We are fully compliant with regard to the front yard setback requirement under the zoning. The building height is compliant, as Mr. Posada pointed out. Building coverage and habitable floor area and habitable floor area ratio are all compliant. The garage, the proposed one-car garage that is located on that southeast side of the building extends 12.72 feet into the required setback. And I'd like to keep in mind the fact that if that garage were a detached garage, it would be located only 5 feet from that rear setback and be compliant. And that main house itself would be compliant with regard to front, side, and rear setback. So by doing this, in our opinion, we believe that we're providing you with a C2 alternative to strict compliance with the ordinance. By attaching the garage, we're actually providing more light, air, and open space to the adjoining properties. And keep in mind that the adjoining lot is actually a side yard, which in this zone, the only requirement is 10 feet. So we believe that we have a good design here. Yes, we need a variance, but I think it's an appropriate one, and I think that the metrics of the site with regard to other setbacks and coverage and height are all compliant.
So, Mr. Lanzafama, you believe that we can satisfy both the positive and negative criteria?
I believe you can.
And you're also a licensed planner as well,
I am a
correct?
licensed planner as well,
Okay,
yes.
Thank you. I have no further questions for this witness.
Thank you.
Does anybody on the board have any questions for this witness? Does anybody in the public have any questions for this witness? 2 down, 1 to go.
Okay.
All right, in the interest of time, that's my last witness for tonight. I would ask the board to consider voting in the affirmative for this project, and as mentioned by the board commissioner, I believe given the height for the front 2 steps requires a railing, so if this board were to find in the affirmative, we would agree to that as a condition of approval to install the railing.
Okay, does anyone in the public want to make any statements? Do you have any other closing statement? Are you good?
Nope.
Okay, I'll just say I appreciate the way you positioned it, with the garage where it was. I think testimony was good on that, providing, to provide the relief required. Does anyone want to make a motion?
I'll make a motion with the condition.
I'll second it.
Okay, Mr. Kenya, Mr. Sherman?
Yes.
Mr. Horn?
Yes.
Mr. Shaw?
Yes.
Mr. Weisman?
Yes.
Ms. Soho?
Yes.
Mr. Beer?
Yes.
Motion carries.
Thank you.
Okay. Yep. The next one, Block 1002, Lot 21, 62 Bryant Drive, application number 2025-61-3, 14 Waterfall Drive LLC, applicant seeks approval to construct a new single-family house in violation of the following section: 170-99C2, front yard setback 40 feet required, 30 feet proposed, 10 feet variance requested, 170-87CC4, habitable floor area ratio, 30% allowed, 33.4% proposed, 3.4% variance requested.
Good evening again. Matthew Pasava, law firm Sills, Culmerson Gross. I represent the applicant, 14 Waterfall Drive LLC. As previously mentioned, that is correct. We are demolishing to propose a new single-family home on the subject site. What you'll see is that for the site itself, as you go back, it becomes more pinched in. And because of that irregularity is what's triggering the actual variances here. But you'll see that the proposed improvement, although exacerbates the existing front yard setback, does eliminate the rear yard setback for the proposed improvement. In addition, we are requesting the ratio, but we are satisfactory for the actual habitable floor area itself. With that being said, I'd like to introduce my first witness, Jose, our architect. Followed by Jose would be Nick Graviano, our planner.
Okay.
Do you swear affirm and tell the truth for the zoning board tonight?
I do.
Can you please state and spell your name for the record?
Absolutely. Jose Carballo, C-A-R-B as in boy, A-L-L-O.
Okay, and let's have Mr. Carvalho's qualifications on briefly.
Absolutely. Graduated from NJIT in 1980, received my license in 1986. I've been in front of many, many boards in New Jersey, and I've been in front of this board many, many times as well. So I hope you can accept me as a...
Does anyone on the board have any questions or objections regarding this witness? There being no objections, the witness is accepted as expert in architecture.
Great. Jose, did you have an opportunity to visit the subject site?
Yes, I have.
And were you the architect who prepared these plans?
Yes.
Why don't you walk us through what you're looking to do here tonight?
Absolutely. First thing I'd like to do is just walk you through the site plan itself and the site. Property is located at 62 Bryan Drive. It is a trapezoidal site, as you can see from what I have on the images I have on the screen. And because of the trapezoidal shape of the property, the building envelope also became a trapezoidal shape, which became somewhat challenging in designing this building. As you can see, the existing building on the left-hand side, the site plan on the left, that building actually goes beyond that building envelope, not just in the front, but also in the rear. If you look at the site plan on the center of the sheet, you're going to see that we try to work with the setbacks as we had them, as well as try to minimize the variances. We actually have two variances. One is the front yard setback. We eliminated that existing rear yard setback. That doesn't exist anymore, so it's just the front yard setback, as well as the habitable floor area ratio, which instead of the 0.3 is 0.334. The building itself is 3,154 square feet, taking into account that 42 of those square feet are actually in the garage, because we exceeded it by 42 feet beyond the 450. So you can see that it is not a large building. Let's see. All right. Okay. I know it's here somewhere. Close that out? Yes. Okay, great. Okay, so here are the plans. Thank you, by the way. Here are the plans, and that's a rendering of the building. As you can see, it's a two-story building. Two-car garage. It has a front porch. No different than most of the properties that you've seen tonight. Basically, you have your first floor is your more public areas, your living room, dining room, kitchen, the garage. On the second floor, you have all of the 4 bedrooms. I'm trying to go a little fast here so I can get you out before midnight. The basement is wide open basement. It just has the one office on that side. As far as the elevations, again, you can see that it's a 2-story building. All of the siding is, most of the siding is a James Hardy board.
This portion here is a composite material that it's wood. It looks like wood, so just to break up the building a little bit. Height of the building is a little less than 31 square feet. The attic inside is about 6.5 feet, and that's at the highest point where the peak is. As it goes down, obviously, it becomes less than that height, so it is not a usable, habitable attic. It's accessed through a pull-down stair, which obviously it's just for storage. Aside from that, it's your typical building. It complies with all of the other, bulks and requirements of the regulations. So, again, I think I don't have any more testimony and have any questions that you might want to ask.
I have no further questions for this witness.
Anybody on the board have any questions for this witness?
Sir, can you explain your rationale about placing the house at 30 feet rather than 35 feet?
So again, it was, as I explained before, I think we're trying to eliminate the rear setback to have one less variance. So, and because of the shape, the trapezoidal shape of the building envelope, the house just became to a point where we had to push it forward another 5 feet. The current house is 35 feet. This is at 30 feet. So it is basically the same variance, the same condition as it was before. And I think Mr. Gorbiano is going to get more, a little deeper into the reasons for all those variances.
Right, but essentially by maybe potentially reducing the width of the house, we can comply. It is possible to comply with bulk variances.
If you look at the plan of the house itself is not that large. And if we needed to cut a foot, 2 feet, or a distance of that, that nature, it would harm the house more than it would actually help, the condition of the variances. So I don't think that a foot or two would help in this situation. And, that the house is just, it's as small as it can get. I'm not sure that we can squeeze, too many more square feet out of this.
Thank you.
You're welcome.
Does anybody else on the board have any questions for this witness? Does anybody in the public have any questions for this witness? Actually, I'm just looking, just one question on the setback in the rear. You say it's 38.9, but it looks like there's a point that's a lot closer, not to bring up a change in numbers, but if you look at the back left corner, that looks like it's right on the rear yard setback, so.
Right, it's about a foot inside the rear setback line.
So how do we have 38.9? The minimum should be less, I think. Not that it changes, it doesn't add
Right,
a variance.
it doesn't
but
create
it's
a
not
variance.
But it's not correct, right?
Yeah.
So it should really be 36 feet.
We'll reflect that.
Okay.
But it doesn't create a variance.
No, I just want to make sure records are correct.
Sure.
No. You have a question?
Yeah.
Please, come up to the mic.
Once again, Stuart Levitch, I affirm.
Address again, Mr. Levitch.
60 Bryant Drive.
Thank you, sir.
I'm the adjacent neighbor. I had questions. I wish the applicant's engineer was here, but if I can add something to the record for him?
You can,
So
well,
a
you can-
statement?
Yeah.
Yeah.
It's fine.
Yeah,
Yeah.
go ahead.
Okay. As I said, my property is located adjacent to the east and down gradient from the applicant's property. As it stands now, rain and melted snow runoff from his rear yard travels from west to east and onto my property, and either to the back of my house or down between the houses to Bryant Drive. Any additional runoff from the new larger building footprint would exacerbate this existing condition. I also wanted to point out that there's a storm sewer inlet located on Bryant Drive in the middle of the property, which should be protected during construction. Let's see, and question for the board or for the attorney, the board attorney. If I have questions about dust control or stormwater management or soil removal, that should go to the township itself?
Right, so anything with regard in terms of the process of construction, that would be code.
Right.
enforcement or engineering. Once again, I think as I said in the prior one, there will be, these plans are meant for the board. They're not meant as the final plans that are actually submitted
Okay.
for engineering purposes. But I think that to the extent that you're a neighbor and you wish for the construction to be handled in a way that minimizes the impact on your property is more than reasonable.
Right, and especially when it comes to the soil erosion and sediment control. 'Cause,
Well, they will have to ensure when it gets presented to the engineering department, they'll have to provide us more detailed soil erosion plan and, in terms of maintaining the property.
Right.
As well as the stormwater
Yeah, we're going to be
controls.
increasing the impervious coverage, so we're going to have to submit a lot surface drainage
Right.
permit to the engineering department. And whatever the recommendation is of the civil engineer for this municipality, we would have to comply.
Okay, now, the question was, would I be able to get a hold of those plans once they're submitted?
Those would be, anything that's submitted to the township is a public record, and you would then be able to view them through the engineer, you go to engineering or code
Okay.
department. They'll be.
Would I be notified that they're there?
No.
No, so-
No. But since you're next door neighbor, you more than likely will see something going on, and then you can
Yeah,
probably.
okay,
Go over and ask them.
okay.
Okay, thank you.
I should just mention that I was a zoning board engineer for 3 municipalities, but this is the first meeting where you get preliminary plans, and I'm used to getting the complete set once everything's been submitted and looking at. That's why I raise these questions to you.
Very valid question.
Okay, thank you very much for your time.
Thank you, sir.
Thank you. I'd like to call my last witness, my planner, Mr. Nick Graviano.
I have no objections to any of the variances.
Okay.
Thank you.
Thank you, sir. Appreciate
Now
it.
you can go home.
You just approved
take
it.
care.
I meant fighting it would do no good, so.
I didn't pay him, I swear.
What a
All
plan.
right. Mr. Graviano, do you swear firm and tell the truth for this board tonight?
I do.
Okay, Mr. Graviano's qualifications are extensive and continue to be valid, correct? As a
Certainly.
planner.
Thank you. I'm going to keep this brief. You've heard the merits of this application. The applicant is requesting front yard setback relief. We've looked at that in detail, as well as habitable floor area ratio relief, requesting 3.4% with this application. As indicated in the architectural testimony, the 3,154 square feet proposed for this dwelling is under the required 3,220 required for the district. The applicant's proposal is roughly 5% under building coverage, so this is certainly a house that is appropriate for the site on which it is proposed. Looking at that front yard setback variance, I do believe that due to the exceptional shape of this specific piece of property, a strict application of the zoning ordinance would create undue hardship on the applicant. As you could see on the plan up there, the corner of the left corner of the applicant's dwelling pretty much lines up with the neighboring property to the left. This is a street which has curvature to it, as I noticed earlier today. Additionally, I would like to note that the applicant is eliminating that deficient rear yard setback, which presently exists at 27.6 feet, whereas you just heard that 36 feet is proposed. So you have roughly 8.4 feet being added to the backyard, while that 5 feet's being subtracted in the front yard, given the fact that the applicant has a two-car garage and a two-car driveway. I think that front yard setback variance could be granted without substantial impairment to the zone plan or zoning on the ordinance, both under the C1 and C2 criteria, and with the C2 criteria advancing purposes of zoning A, G, and I of the municipal land use law. Looking at the FAR variance, the site can certainly accommodate the increased FAR. The applicant's meeting all of the side and rear setbacks, which really impact the neighboring property owners, and there's no substantial impairment to the zone plan, zoning ordinance, or public good with the granting of the FAR variance.
I have no further questions.
Just a quick question. So you, in your opinion, then, it's better to have the house a little bit further to the street than back towards the rear yard?
Certainly. I think, given the context of this neighborhood, it's not a substantial deviation from the neighboring property owners. The curvature of the street actually makes the corner of the house line up with the corner of the house to the left. And additionally, given the extreme shape of that property, pushing the house forward gives it a legitimate backyard.
Thank you. Does anybody else have any questions for this witness?
Yes, I do. The porch is allowed to encroach 6 feet into the front yard. Looks like the porch and the steps encroach more than that. So I believe you'll be looking for a variance which is more than 30 feet
The applicant will comply
with,
with the zoning code requirement,
With the 6-foot encroachment?
with the
No more?
no more than 6 feet.
okay. So would you be redoing the steps, the elevation? Like what, the reason you have the porch and the steps is because you are elevated from the ground. That you can come from the grade level onto the first floor. So what is it that you are planning to
If I may, I'll
modify?
call my architect. It's an
Sure.
architectural question.
Across the bar here. So, yeah, we'll comply with that. I think we're a foot and a half over. We'll pull it back in. The landing is actually 5 feet. We'll pull it back to 4 feet. And if we have to push that center of the house back to accommodate that, we'll do that. But yeah, we're not asking for any relief on that.
Okay, thank you.
Does anybody else on the board have any questions for this witness?
And what about do you know the setback of the house to the right?
They're both at 35, left and right.
Okay, no.
Anybody else on the board? Anybody in the public have any questions for this witness?
Waive.
Okay. Does anybody in the public want to make a statement? Anybody on the board want to make a statement? Anybody on the board want to make a motion?
I'll do.
I'll second it. Since I knew you were going to say
Mr.
approve.
Sherman,
Yes.
Mr. Horn,
Yes.
Mr. Shaw,
Yes.
Mr. Wiseman,
Yes.
Ms. Sohail.
No,
What'd you say?
no.
No?
Do we need a reason for that? Yes.
Just
Yes.
bring a reason?
So
The
let me-
reason is, yeah.
One second, let me just make this statement, I should have done this before. Anytime when a board member is going to vote no, please make sure you state on the record the reasons for voting no. If you're voting yes, that's perfectly fine, but if you're voting no, we do need your statement on the record. So, just an advisement. Thank you for reminding me.
I just feel that the homes to the left and the right are 35 feet. The existing home was at 35 feet. By making it 30 feet, I just feel the variance that is requested can be, we can overcome and not request the 5-foot variance that the applicant is requesting.
Mr. Beer?
Yes.
Okay, motion carries the way it is.
Thank you.
Yep. Hang on. Take care.
Okay. Now this is the next. Okay. Block 4009, lot 16, 33 Mount Haven Drive, application number 2025-66-V, Rodak Home Incorporated. Applicant seeks approval to construct a new single-family house in violation of the following section: 170-99C2, front yard setback 40 feet required, 52.0 feet proposed, 12.04 variance requested. 170-87BB4, habitable floor area 3220 square feet allowed, 3998 square feet proposed, 778 square feet variance requested.
Okay. Before we continue, I just want to clear up a jurisdictional issue. It's not a jurisdictional issue. Ms. Posada was looking at me getting excited for a second. No, just to clear up. So, Ms. Posada put out a notice for this application, and the notice included the variance requested, but I believe that the issue was that the number was not the same as the number in the plan. Is that correct, Mr. Posada?
Yes, that's absolutely correct. So what we had done was we had noticed for a total of 2.04 for variance relief, whereby the zoning denial was for 12.04. Reason why we did 2.04 instead of 12.04 is specifically because when you read the front yard setback definition, at the end it says, nor needs setback more than 50 feet. So because of that, and this is 52.04, we did the simple math and just said 2.04, but nevertheless, it's still noticing for the 52.04. In addition, the public notice itself has the omnibus clause, AKA the catch-all, that in the event that the board has a different interpretation, it still gets assumed.
And I would agree with Mr. Posada that a typographical error like this is not, doesn't remove the jurisdiction of the board to hear the application. The front yard setback variance was included in the notice. The numbers of 40 and 52.04 were included, just the variance piece, which could either be viewed as, you know, attorneys don't do math very well, so perhaps we can put that on Mr. Posada, that it's a 12 and not a 2, but that's why he didn't become a CPA.
You stole my line.
So, exactly. I just want to place that on the record. Obviously, if there were any interested parties in that application would be here, and we would explain that to them, but the board has jurisdiction.
And on that note,
All
there
right.
is a variance then on the zoning table.
Yes, there is.
Okay,
Yes.
so
So we'll go through that relief.
just want to make sure that's clear.
Yes.
Okay.
Yes. So I represent Rodak Homes Incorporated in connection with this application that we have here before the board. The benefit of being able to spend the entire evening with the board gave us the opportunity to review our architectural plans a little bit more and really think to ourselves, is the proposed habitable floor area really consistent with the master plan and zoning ordinance, or maybe should we make some tweaks? Considering the fact, though, that the parcel itself is nearby the R3 and the R4, we thought to ourselves, why don't we come down a little bit? So in a nutshell, our proposal is going to be modified just a bit, where approximately 300 square feet will be removed. So instead of it being 3,998, help me out here, board attorney, I believe it's 3,698 roundabout that we'll be proposing here. But don't take my words, take the words of our architect, Mr. Eamon Cedra.
So just to be clear, Mr. Posada, what the board's going to be seeing tonight is revised from what is part of what's been submitted?
Yes, that's absolutely accurate. So what we're going to do here tonight is we're going to walk the board through our proposed plans and the exact modification that we're looking to do to reduce the habitable floor area. And we would just ask this board that, as a condition of approval, those modifications have to be satisfactory upon submission for resolution compliance.
Okay. And that would, so if there's a reduction in habitable floor area,
We'll have to tell you
There's
on
a-
the record what that is going to be so that we have the requested relief here tonight.
right, but wait 1 second, let's go back 1 second. So the drawings which have been submitted had shown 3,998 square feet.
Correct.
There are new drawings which are being presented tonight, which is,
No, but
He's
it
going
said
to talk us through the changes that they're proposing. Is that okay, Jackie?
just-
Mr. Chairman,
that-
I would request that the architect submit the revised architectural plans
Right.
before the preparation of the resolution.
we can absolutely adhere to that if the board would find favorable, so we know what we're revising.
Okay, so we don't need to see the plans before we rule on what they're saying, just as long as we see them before resolution. That's what I was concerned with. I think you were too.
right.
I could be
There you
aware.
go. No, that's where, okay. We're all up to date. Go ahead.
It's getting late, guys.
All right, so Mr. Cedra, I'm sorry, do you swear for and tell the truth for the zoning board tonight?
I do.
Okay. Mr. Cedra's qualification has been placed on the record as an architect. Chairman?
Does this board accept them?
Yeah, we can accept you as an expert in architecture.
Thank you. Mr. Sedra, why don't you walk us through the modifications we're looking to do and approximately what square footage we'll now be proposing so we understand the relief being requested here tonight?
Sure. Originally, this house was 3,998. That's the habitable floor area. And the variance we're asking for a 778 square feet variance. We are proposing to reduce that by 300 square feet. So our final number for the variance will be 478, and that will happen by reducing or cutting, I believe, about 2 feet off the back wall. So I'm going to shrink that 2 feet, and also I will cancel the breakfast area and the office above. That will give me the 300 square feet that I'm reducing here. This is a brand-new house. We have all the living spaces at the first floor, the second floor for sleeping, and we have a recreational area at the basement level. By doing this reduction, we only applying for 478 square feet habitable floor area ratio.
Ms. Sedra, give me
I'm
that
sorry,
one.
habitable floor area, not the ratio. We're not
Yeah.
applying for ratio.
And just for clarification again, Mr. Sedra, what we're looking to do here, if you could just point to the map, to the board behind you so everybody can see what we're looking to do. We're looking to eliminate that breakfast nook and then also bring in the rear building envelope by 2 feet, correct?
Correct.
Okay. All right, why don't you walk us through the proposed plans with those modifications?
So that's what's going to happen in the first floor. The second floor, we will cancel the office. The master bedroom and the bedroom number 2 will get reduced by 2 feet. But when I say get reduced by 2 feet, there is also a chance that I will adjust the spacing, the intermediate spaces, so the 2-foot cut is not coming from the master bedroom completely. Maybe 1 foot from the master and 1 foot from the closet/master bathroom. Bedroom number 2 is very big, so we can cut maybe 2 feet again, or adjust the bedroom now 1 and 2 to get this reduction. The style of the house, it's a colonial style home with some modern accent. We will use dark roofs, and we will use Hardy boards and board and batten, James Hardy board and batten. We'll use some standing seam metal roofs at the bay windows. Also, we're using a stone at the base of the building. And that's pretty much it.
Just for clarification, the attic itself is pulled down, correct? It's not walk-up?
Correct, yeah.
Okay, and then again, as far as it goes for the reductions that we're going to be doing here to reduce it by 300 square feet approximately, we're looking on the first floor to bring in that back envelope line by 2 feet, a recess of 2 feet, which would include the removal of the breakfast nook area. And on the second floor, we'll be modifying both the bedrooms and also the office space as well,
The office space will
correct?
get canceled, yes.
Okay, and this is for, and you think that the proposed improvement is consistent with the zoning plan?
Yes, correct.
And also master plan, considering the fact that the lot is about 7,000 square feet oversized?
Correct.
Thank you. I have no further questions for this witness.
Also, I would like to mention that the attic height is 7'3" from the attic floor to the ridge beam, with putting the collar tie at 4'8".
Does anyone on the board have any questions for this witness?
So,
Go ahead.
if you're reducing, maybe I'm losing it, but if you're reducing the square footage, you're also, is there a new ratio? No, I'm sorry.
We don't have
I'm
a
sorry, I'm
ratio
looking,
variance.
this is why you shouldn't make decisions at the bar at 11 or at the zoning board dais at 11. I'm moving on. Sorry, looking at the next one. I'm getting excited. Was moving on to the next one. No, go ahead, Mr. Posada, I apologize.
I have no further questions. You stole the show.
I apologize.
So when you make the house a little smaller, does that mean the roof's gonna be coming down a drop?
The roof will come down a little bit, yes.
Okay, I think that'll help, because I was concerned about the mass of the house from the streetscape, compared to what's out there currently, mostly much smaller houses, and I was a little concerned this takes over the neighborhood, but we can talk more about that, I guess. Does anybody else have any comments?
Yeah, well, not sure if it's for Mr. Cedra or Nick, but I'm looking at the setback study. I see the other lots that you did, which are all about 36 to 35.55 to 37. You want to push this house back to 50, whatever it is, 52 feet. I don't understand why, setting this house back that much further than everything else out on the block seems to be out of character by a lot.
We can have Mr. Cedra just explain the design itself, but as far as the relief and why the location, Mr. Graviano will testify to that.
Does anybody else have any questions for this witness? Does anybody in the public have any questions for this witness? Yes, okay, come on up. That's all right. You've been sitting there patiently.
Tarot Sony, 25 Harvest Lane.
We'll swear you in again. Do you swear firm and tell the truth for the zoning board tonight?
Yeah, sure.
Okay. No worries. All right, and you stated, and you were kind enough to spell your name the last time and your address once again.
Yeah, sure. Tarun Sony, Tarun Soni. Keep it simple.
Okay, and address?
25 Harvest Lane, Livingston, New Jersey.
Good, sir.
So I'm living pretty close to this house and all, and as Ed mentioned, giving the character of the house and everything, given they can cut 39 to 3600, why not they cut 36 to 3200? I want to know what is the hardship that is driving. It was also mentioned that it's a new construction. So what entails a new construction, such hardship that it is warranting a 3600, 3700 square feet of space that Rodak Homes is trying to build here?
I believe this question is more appropriate for the planner, who will be my next witness, and we'll absolutely address that.
Okay, so that'll be addressed by the planner, yep.
All right, I call my next witness.
So no,
There's no one else.
I have one question, right? So I fully appreciate that while it is a zone 4, or R4, sorry, it is, really an R3 from a lot perspective, right? And I appreciate you bringing it down, because I would have raised that. You're still above, at your 3698, what an R3 would be. And given you, I get the lot is a R3 lot in an R4 zone, you're still 178, I can do math still, square foot above even a zone 3. So I would still say, is there a way to bring the house even down a little bit more? So while you're in R4, at least your lot's an R3 lot to kind of conform with the R3.
Mr. Cedra, is there any other tweaks that we can make to reduce it, while still keeping the character of your proposal?
And I think it is, I get the point, but I think a couple of us feel it's a little hard to you're taking this off, you're moving this wall, you might move it over here, for us to kind of approve without seeing what the new house is gonna look like.
I can maybe, would 50 square feet help? I can maybe go to 350? That's without doing
I'd like to I would jump in on the same thing. And I know Nick's going to talk about the area, but this is an R4. The house is an R4, but backs up directly to an R. The backyard is an R3. So it's an R4 backed up to an R3. This is R3 basically sized lots within the R4 zone. And yeah, in reality, they should be closer to the 3550 that an R3 would be, just to be in character with the R3 zone that it backs up to and
R4 zone.
the size lot within the R4 would make the most sense.
So, Mr. Cedra,
I agree on that. I agree on that as well.
I think we're looking more like another reduction of about 100 square feet. not 50.
Yeah, I suppose we can make that work.
Okay. Where, though, could we make it work?
I will have to cut some square footage from the depths of the building, so I will have to shrink it even more.
So what you're saying is that you can reduce it down to 3,598? Is that what you're saying you can get to?
Yeah, 3,598, yep.
If it's acceptable to this board, we'd like to move forward and then also have our planner put the testimony on the record with the understanding that before a resolution could be adopted, we would have to show you guys plans with a habitable floor area of 3,598.
I think we are looking for 3520, because that's what's allowed in R3.
3550.
35, I'm looking at the zoning table right now. 3520.
3520, sorry.
Yeah.
Can I chime in? Because we're asking questions, so my statement would be, I'm not with the board on the 3520. I'm at the R4. I've seen the block, I drive down it all the time. Looks like an R4 to me. You know, I wouldn't, that's not my sentiment, so I wanted to convey, my sentiment is that it's an R4, right? It's 3220, I think. That would be my sentiment, looking at this block.
Well, let's remember this. This is in the R4 zone, so the applicant, anything the applicant proposes is in line with what the standard is for an R4.
Correct.
So even if the applicant were to make a change that would apply in another district, it doesn't change the fact that the applicant still needs to obtain a variance. The applicant has the opportunity to argue that that's alternative size and its applicability in another zone or similar situated lot. They have the opportunity to make the argument that that's in their position appropriate. But once again, this is just so everybody on the board's clear. This is, you know, regardless if it looks like an R3 or looks like an R1, it doesn't change the fact that it's still, the standard is R4. And that's what this applicant would have to meet, just so we're all on the same page with that.
If I may request from the board, I think about a handful of the board have now provided their comments. If maybe we can get everybody else's comments and then have this matter carried to the next available hearing date with the revised plans. Just a hunch.
Yes.
Seems probably a way to go. Would anybody else like to make a comment?
The only other thing, I just want to make sure if you're going to come back with plans, I mean, I know if Nick's not speaking, just to take into account, because we didn't hear about the front yard setback. So that's obviously another issue here that we didn't, you know, really discuss, so.
Diligently making
I am.
I mean.
Oh, my God.
I'm sorry.
From the Munsters.
You can lay right in there.
Yeah, from the Adams
You
family.
could.
Yeah, well, he's trying to lay a house right in there.
Should have got a job at Busy.
Okay.
All right, so with that, keep an eye on me. Okay, so with that in mind, Ms. Posada, are you asking for a continuance of this matter for your client to take the commentary from the board and determine what amendments, if any, you want to make to Mr. Cedra's plans, and also eventually at the time for Mr. Graviano's, assuming Mr. Graviano's going to come back and testify?
Yes, that is accurate. Requesting an adjournment so we have an opportunity to reconvene and make the recommended revisions that we think would be appropriate pursuant to the board's comments. And in the interim, we just ask that if this board would allow us to adjourn it, that they also allow us to carry the notice.
Yes, I think that's not a problem. Jackie, when would be the next available date? Anytime this year?
Great.
She's looking. Give her a second.
Mr. Chairman, that would be Tuesday, October 28th.
Tuesday, October 28th. Thank you, Jackie.
Can't wait to see it.
So you are adjourned until Tuesday, October 28th. No further notice is required.
Thank you.
Thank you. And last but not least, one more.
Now we're on the Apple
You got it?
Okay, Block 902, Lot 3, 24 Northridge Road, application number 2025-67-3, Rodak Home Incorporated. Applicant seeks approval to construct a new single-family house in violation of the following section 170-87CC4, habitable floor area ratio 30% allowed, 35.42% proposed, 5.42% variance requested.
Good evening again. My name is Matthew Posada. I hope I'm still employed by Sills, Cummins & Gross, and I still represent the applicant Rodak Homes Incorporated. What they're looking to do here tonight is demolish the existing improvement and develop a new single-family home. The home itself is on a lot that is currently undersized, so because of that, we are triggering the ratio variance. However, we are keeping with all other bulk measurements. So the only variance we are seeking here tonight is just the ratio and the ratio itself. I'll have two witnesses. First an architect, second a planner, and then I'll wrap it up. So if I may call up my first witness, I'd like to call up our architect, Eamon Cedra.
All right, Ms. Cedra, once again, do you swear firm to tell the truth for the zoning board tonight?
I do.
Okay. Ms. Cedra is accepted as, has been accepted as an architect about 5 minutes ago, and I'm sure that he's still qualified as an architect in the state of New Jersey.
Great. All right, Mr. Cedra, why don't you walk us through what we're looking to do here tonight?
Sure, yeah, we're designing here a single-family house. We have all the living spaces at the first floor, and also we have a guest bedroom. The area of the first floor is 1,488. The garage is 438. The basement is just for recreational. We have playroom, media room, and a rec room. Also, we have a bedroom. The area is 1,488. The second floor consists of four bedrooms, and we also have the closets and bathrooms. We have a laundry room. The attic is accessible through pull-down stairs from the second floor corridor. The second floor area is 1,732 square feet. The floor area ratio is 35.42. We're asking for a 5.42% variance. We meet the requirement for the habitable floor area as our square footage is 3,220. We also have an open space, open foyer, counted twice, but only used at the first floor. And this area is 46 square feet. The house design, again, it's a colonial style home with board and batten on the vertical walls, and then we have horizontal James Hardy boards. We have casement windows, dark roofs, and standing seam metal roofs above the entry and also above portion of the garage. The attic, from the attic floor to the underside of the ridge beam is 9 feet, and we have the collar tie at 6 feet from the attic floor. That's all.
Great. I have no further questions for this witness.
Does anybody on the board have any questions for this witness? I don't think anyone in the public has any questions.
All right, I'd like to call my last witness, Mr. Nick Graviano.
Last but not
Graviano,
least.
do you swear firm to tell the truth for the zoning board tonight?
I do.
Okay. Mr. Graviano's been qualified about 10 minutes ago as a planner, and his license is, I guess, still good.
Thank you.
All right, Nick, why don't you discuss the proposed relief we're requesting here tonight?
Yes, the applicant is requesting a 5.42% FAR variance request. The application meets all of the other required yard setbacks. The applicant's meeting the front yard, side yards, aggregate side yard, as well as rear yard setbacks. Certainly, when looking at the FAR variance, the applicant must demonstrate that the site can accommodate the proposed use withstanding the FAR variance relief being requested. Certainly, the applicant's meeting all the required setbacks, as well as all of the required off-street parking. This proposal certainly advances purposes of zoning A, G, and I of the municipal land use law. There's no substantial impairment to the zone plan or zoning ordinance with the granting of this variance. The applicant is meeting the 3220 square feet habitable floor area requirement of the R4 district. So there's no substantial impairment to the zone plan or zoning ordinance with the granting of the FAR variance.
I have no further questions for this witness.
Does anybody have any questions for this witness?
Sorry, I didn't see a site survey. Do you have a site survey? You can display?
I'm sorry.
A proposed survey?
Yeah, there's a survey as part of the package.
We got it. It's on site plan.
Not shown here, but I have it on a flash.
You want to see? While she's looking, I'll ask one question. Mr. Graviano, can you just testify to the way the house fits in with the neighborhood, the massing of the front of the house?
Certainly, had a chance to go to the subject neighborhood as well as look at the tax records of the surrounding properties. Within block 902, lots 21, lots 11 are over 3,000 square feet, consistent with the applicant's proposal. I would like to note that tax records and zoning square footage calculations are different. Tax record square footage calculations are actually lower than the zoning calculations because they don't count things that the zoning count. So I felt that the proposed dwelling is certainly in keeping with the established character of the neighborhood.
Okay, thank you. Any further questions? Okay. And I think we're still good on the public.
Agreed.
Yeah.
I'll make a motion to approve.
Unless you want to have a closing statement.
Nah,
Oh, sorry, Matt.
no thank you. I appreciate the ask.
You're welcome.
I'll still make a motion to approve.
I'll still second it.
Okay, Mr. Horn.
Yes.
Mr. Sherman.
Yes.
Mr. Kenya, yes. Mr. Shah.
Yes.
Okay, Mr. Wiseman.
Yes.
Ms. Shohel.
Yes.
Mr. Beer.
Yes.
Good night.
Thank
All
you,
right.
everyone.
Motion to adjourn? Second?
Second it.
Adjourned.